20 and 21. Yes. Why don't you? There is this mention slip by circulation. Use that. This is for all councils. It is available. For where both councils agree, you sign and give a copy to the court master. All right. 20 and 21. 2021, and the request made on behalf of the respondents, Oil India, matter stands deferred to be listed after 4 weeks. Counsel for the petitioner does not object to the prayer made. However, submits that the interim order passed may be extended. Stop. Vera, list again after 4 weeks, interim order, wherever passed, will continue. Yes. No. Don't have to apologize. I am saying that it is there. Next time onwards, you can take use of this. That's all. Oh. Who's for the petitioner? Okay. 23 stands deferred to be listed after how much time? 1 week. All right. On the request made by Mr. A. Dhor, counsel for respondent 1, 2, and 3, prayer made is not objected to by the counsel for the petitioner. Yes. Yeah. Listing. What is the subject matter? Next week. All right. For admission. 29th. Item 13, on the request made by the counsel for the petitioner, matter stands deferred. Matter stands dismissed on withdrawal on the submissions made by the counsel for the petitioner. Interim order, if any, stands vacated. Pending ayes are also dismissed. Yes. 29. When do you want 29th? First of September. Hmm? 105. Oh. For withdrawal. Item 105 on the instructions. On the submissions made by the counsel for the petitioner, matter stands dismissed on withdrawal. Interim orders, if any, stand vacated. Pending ayes are also dismissed. Yes. No, this mediation. Wait for the matter to be called up. Yes. What is the subject matter? 29th. 27th. Motion matter. Why the urgency? Not tomorrow, next week. 27th. 27th. Please correct the date. Yes. No, let it be. It's a fresh motion. So let it come on 27th. Yeah. For admission. 29th.
For admission, I think one.
Hmm.
How they are saying that I become the finance. So they have already
You represent the finance, you get it. Hmm. Hmm.
either it is 7 times initial order has gone laid out with purely case contempt. It is case of ransom. This from 19, a ransom case is pending for 7 years. How far will counsel not it being decided? Actually, it needs to be decided. It could be directed for production of records. I have already communicated. They are saying that the records now. What's it by all the orders? How did it that from starting from April, records of this being produced, this is all the time. So this is 4/4/24 order, what is finally paid on the order first. Then project. That is the 27/1/25. Then again, 5/2/25. Then location. 20/2/25. Then 5/3/25. How this 7 years locked, this process is going on. How the people is supposed to show in it is going on for 7 years.
You produce it by next week. Tuesday. Next Tuesday.
Then
We are making it clear.
very
Heard Mr. H. Raman, Senior Counsel, assisted by Mr. So-and-so, and Mr. P. Nayak, Additional AG, Government of Assam. Mr. Nayak submits that in reference to the order dated 29/7/2025, the records directed to be produced before the court was sought to be produced, was sought for. However, the communication seeking these records sought for by the council. In response to that letter, the department informed that the records sought for are currently available before the finance department, finance within bracket economic affairs department. He submits that 1 week's time be granted and he be permitted to obtain the records. 1 week will not be Tuesday. Considering the submissions made and the instructions placed before the court, matter stands deferred to be listed on 2nd of September. It is made clear that if the records as directed are not produced, court will take a serious view in the matter and proceed to pass consequential orders. If they don't file, then we can't help it. They don't file, it's their call. Mr. Dotto for the Panchayat and Rural.
item 2 to 4.
Yes. Hmm? Yes.
I have no objection. Only objection is that it is a norm. It is a recognition is not maintained. We have raised the preliminary issue that it is not made. We have not filed a detailed affidavit on the other issues which we have raised.
What is the?
His submission is that Lordship may take up the matter for consideration of the maintainable today.
What
If
is,
it is,
what is the issue here?
issue is basically, Lordship, whether they are basically aggrieved by a new pension promotion policy of the ONGC. They are aggrieved by certain conditions of that policy. And the appropriate forum, in my humble submission, when a dispute relating to industry is raised, the appropriate forum is the Industrial Tribunal. And that is a settled law by Supreme Court as well as various other high courts, including Delhi High Court, specifically on the same point. So they should approach the Industrial Tribunal to agitate their grievance. If they want to pursue here, Lordship, they can pursue, but first this issue has to be decided whether Lordship will finally decide, take up the matter for consideration or not.
What is your submission, Mr. Sokia?
Here actually there is no dispute as such. While I was, where all these petitioners, when they were appointed, the recruitment and the promotion resolution of 1980 was in force. As per the said regulation, so far as the class 4 employees are concerned, for them there is no avenue of promotion. We were appointed in between 2014 to 2016. We have made a representation that there should be at least one avenue for promotion. We have a right to be considered for promotion. That's a fundamental right. So that representation, the ONGC has forwarded to their headquarters or as such, till that no decision has been taken. So we have approached this on our petition.
Where is the policy?
The policy, I have just annexed the 11th.
Industrial dispute.
There has to be a dispute, they have not rejected even my representation, but then nonetheless, I have come here for violation of my fundamental right to be considered for promotion.
Where is the policy?
This is the regulation, Oil and Natural Gas Corporation Limited modified recruitment and promotion regulation 1980. Now categories and posts are there, now let's will find internal page, which is at bottom below, page number 8, clause 5. These are the 4 classes of post: executive level, class 3, class 4.
Are you not, you are not ready to argue the matter?
If it's, I'm
All right.
Look, this is the class 4, find my page 20.
Huh? Page 20.
Page 20 of the regulation. I'm just taking a look to the various provisions of the regulation first.
All right.
So different classes of posts are, as I have already pointed out, at page, internal page 8, that follows. Then page 20,
Right.
this is class 4.
Yes.
The existing employee who ultimately come to this clause A under the serial number Roman 4. The existing employee with qualification below standard 8 will be treated as underqualified, including sanitary cleaner and muddy MRP 1980. Promotion would be subject to the suite. These are the persons who doesn't have who has the Q3 qualification, who doesn't have the Q3 qualification. Q3 qualification is the qualification which is prescribed for the bottom of the course. That is here, my lord, is the class 3 post. My lord. And so far as, my lord, the next page you'll also find, my lord, page 21.
Yeah.
This other cross code is page 21, serial number 7. No resultant vacancies in class 4 would be filled in. Employee recruited in class 4 under MRPR 80 would not be considered for shifting to the bottom of class 3, even if they possess UC qualification as per RR.
You fall under which category?
4, my lord.
Category? Class 4.
Lord.
So from 4, you are required to get promoted to W5,
To class 3.
class 3.
Class 3. Then to, my lord, executive level.
So you are referring to class 4.
Lord.
This is Roman 4, page 20.
Lordship. Roman 420.
Now, here it shows W1 to W2.
These are, my lord, the scales, my lord. These are not as such promotions, my lord. These are scales.
Okay,
After
so
certain years, my lord, he'll be getting that pay scale. That is the thing, my lord. But there's no avenue from, my lord, this class 4 to class 3. Whereas from class 3 to class, my lord,
what about clause C, Roman 1?
25% of the eligible employee in W4 and higher level may be considered for shifting to the bottom class 3 scale.
8 and 9. Sorry.
Open-ended bottom class 3 of employee. The eligible employee means existing employees. So this is at the time, my lord, when the regulations came, that's the existing employees. Well, first of all, they were not supposed to, my lord, fill up the vacancies in class 4. Indicating that they don't want to retain this class 4 at all, my lord. Now, so far as the earlier rule which was prevailing prior to, my lord, coming into this 1980, for a moment, lordship may look at to that, my lord. There the clear promotional avenue, my lord, were available.
When were these amended?
It is in 1980, my lord. And then thereafter, various amendments have been taken place, my lord.
But why are you challenging it now?
No, I am not challenging the rule as such, my lord. I am saying, my lord, there must be, my lord, there has to be a, my lord, chance, my lord, avenue for promotion, which is a fundamental right, my lord.
Yes. But from these, you are unable to show that the avenue has been done away with.
My lord, the various classes of, my lord, posts are given in the annexure of these rules, my lord.
Hmm.
So far as the class 4 is concerned, they have been confined to the class 4 itself.
Which page?
Yeah, for instance, my lord, this fire service, your lordship will find 136 of the, my lord, this regulation.
Yes. Class 4 is fire service. No.
No, fire service is a, my lord,
Separate
category of service. They
category
have
of service.
class 2 everything, my lord. So far as this,
You are now in class 4, S4,
we are in, my lord, W.
W.
Lordship will find internal page, there's 138. The
W4,
W4.
fireman grade 1.
The bottom of the post is W1 at page 139.
Hmm.
How
Now
I-
you are now at which level?
My lord, we are now presently fireman grade 3. My lord. Just above that.
Grade 3.
Grade-
Fireman
grade
grade 3.
Lordship.
W2.
W2.
Okay.
So this is W14300. Then after 3 years, 4500, they'll be known as W2. So that way, my lord, it is up to, my lord, chief fireman. And then, my lord, this class 2 starts, my lord, with the A1. Junior fire supervisor. So none of these persons, my lord, are entitled to go into that, my lord. But so far as this A1 is concerned, my lord, they can go ahead, my lord. And similarly, in other services also, from the grade 3, from the class 3, they can go to the, my lord, executive level of the post.
Yes.
Well, the earlier, the rule prevailing at page 134 of the writ petition. Lordship will, 1 minute, 137. This is a part of the earlier rules. which
You
were-
have not challenged the policy. Have you challenged the policy?
No.
Then,
But I am saying that since it is my fundamental right.
no,
at least they
fundamental
should-
right, but
they
the
should-
policy has been defined.
Lordship.
If you are aggrieved, you have to put it to challenge.
My lord, my submission would be, my lord, since, my lord, it better concerning the fundamental right, my lord, perhaps the other, my lord, technicalities or as such, my lord, may not come into.
No. Technicalities may not come in.
Lordship.
But how will your fundamental right be brought to you or given to you
Right.
in practical terms? How?
Lordship.
You can't be lifted, you can't be picked up from a particular post and given promotion. There has to be a procedure.
No, there would be
That fundamental right besides you is applicable to others like you.
Lordship. So, my lord, my prayer is, my lord, to direct them to, my lord, my lord, to grant, my lord, a avenue for promotion.
Why?
Lordship.
The policy is there. Whatever is there is there.
Policy
You
doesn't.
challenge it if you agree. Unless you are questioning the policy itself, there is a violative of Article 14, 16. Where is the need for us to redefine the policy?
That, basically, my lord, perhaps this policy would not come as an estoppel, my lord, for me, my lord, unless I challenge it.
No. It will, whether it comes or not, we don't know. But you are claiming promotion by referring to a particular set of regulation to say that certain category of personnel have access to promotion to higher posts,
Right.
whereas persons of your category
Right.
are not considered. So
No,
that particular clause has to be put
I
to
have
challenge.
I have submitted my representation. And what they say, my lord, to that, my lord, that they have referred it to the, my lord, higher authority, that's all, my lord. The decision has not been taken, my lord. So they may take a decision, my lord, to, my lord.
Take a decision.
Lordship.
Inform him. If some representation is pending, take a decision and inform him.
For that, I
Yes,
have
my
no difficulty. I concede to this prayer. That only that representative has to be disposed of. And if he have any further grievance, he will approach the appropriate
No,
forum.
that-
That observation may be
No,
given.
my lord, that at that time it will be
He
decided.
will
my lord.
approach appropriate forum to be anything.
No, otherwise, this is not maintainable because if Lordship is pleased to look at the Act 2K,
No, he has not put a challenge to this.
and that is a page 21 is their prayer. In the prayer, he wants a mandamus. So by violating the existing policy, how
No,
this
he-
honorable court would like to pass
that he has considered, he does not want to pay for it.
he is considering everything now. So I'm happy that he is considering so that I don't have to argue much. But let us go to
Dispose of my representation. Detail.
we'll be more than happy to dispose of his representation this way or that way. But we have to abide by authority. My submission is that authority have to abide by the existing policy or existing regulations in place.
We are not saying anything
Yeah,
more than.
we are not preempting that stage, but let us see K, 2K.
No, we are not even going into that. He says his representation is there, it is not disposed of.
If that is a so innocuous player, Lordship, I will be more than happy to concede that.
Dispose it of.
And Lordship may give a time frame that
will
within
give you a time
30
frame.
days also we have to dispose it of.
Once they deny, then only the dispute may arise.
Yes,
If they accept,
fine.
there is no dispute. Till that there is no dispute.
Right.
So
There's
that
no
is
use
not
of
the
the
prayer in his page 21 in the repetition.
Mr. P.J. Soikia, Senior Counsel, assisted by Ms. Swanso and Mr. D. Soikia, Senior counsel assisted by Mr. Das, hearing for the respondents. All the respondents. The petitioners are employed as firemen. As firemen, at what level? W3? W4?
W level, presently W 3 level.
W4 or W3?
I'll just continue.
What level?
Presently, my lord, fire grade 3, W2 level.
W2.
But W2, initially we were inducted junior fireman,
That you
W1.
know, but presently what is your level?
Fireman grade 3, W2.
Fireman grade 3. Grade 3 is numerical 3.
Roman 3.
Roman 3.
Capital.
W2. Stop. The petitioners were inducted into the corporation by process of interview as junior firemen, W1 level. Stop. Subsequently, they are now placed as W3 level. Stop. The grievance of the petitioner are that under the Recruitment and Promotion Regulation 1980, followed by the ONGC, there are no promotional avenues shown for firemen from grade 4 onwards. Is it? No promotion level from?
From the W2, my lord, from the class 4 to class 2, class 3. We are in the class 4, the promotional avenue to the class 3 is not there.
So please come to 138, 138, 139.
This was the regulation which was prevailing prior to the this 1980 regulation came. Their promotional avenue were there.
Okay. What is the new regulation?
Now the one I have supplied, this.
The one you have supplied is 138, 139. This is the one.
This is modified as of 1987.
In 97, there was a modification. So he has not challenged all these things and he has not
Well,
got those to record also.
What?
1997,
No,
the
no.
amendment one.
I said that is there also, that is there.
No, what is your grievance now?
My lord, my grievance is against, my lord, this regulation at page 128. 128
Of
of the writ petition.
Writ petition.
This is only, my lord, a few, my lord, the relevant portions are given. Detail I have given your lordship, my lord, extra.
128. Yes.
Same thing.
Yes. Now your grievance is?
Under this regulation, we don't have, my lord, promotional avenue from class 4 to class 3.
Class 4 to class 3.
Lord.
Yes.
No, from the chart, it shows that you are now at W2, isn't it?
W2, my lord.
Grade 3.
Grade 3.
From there, you will get promotion to grade 2, grade 1
My
like
lord,
that.
these are not, my lord, promotion up to, my lord, the page 132. The serial number 18, chief fireman W7. This is not promotion. This is just after 2, 3 years, 6 years like that. The scale has been given.
So
So job description, everything,
from
my lord, everything is same.
from serial 18, you don't go above to 17, 16 like that.
Exactly, my lord. And this 17 my lord, falls under class 3.
The petitioners presently working, their grievance is that under the so-and-so regulation, pursuant to the amendments made, the petitioners are placed as class, you are class 3,
4.
class 4 firemen. And there is no promotional avenues from class 4 to class 3 and upwards. Stop. It is the grievance of the petitioners that the other posts which are available and reflected in the regulation show sufficient promotional avenues, except for the posts of
Class 4 to class.
class 4 to class 3. Firemen, stop. The petitioners are presently firemen grade 3 -W Roman 2. And beyond the chief fireman, which is W-7 Roman 7, no further promotion. The petitioners are not, there is no promotional avenue to the next higher posts. So it is the submission of the council for the petitioner that earlier, prior to the amendment of this 1980 rules, the regulation, there was sufficient promotional avenues. But these have been modified or amended, and the regulation of 1980 has been brought into, and no promotional avenue has been provided. Stop. It is the submission of the senior counsel to the petitioner that right for being considered for promotion has been recognized as a fundamental right. So therefore, the authorities, being a public sector undertaking, is duty bound in law to provide sufficient avenues for promotion for consideration of the petitioners and other similarly situated persons for promotion to the next higher post. Stop. The learned senior counsel submits that
The petition is not maintainable.
the petitioners cannot be the exclusion of the petitioners from the purview of being granted promotional avenues it does not have any legal basis. Stop. During the course of the argument, he submits that at present, although the initial prayers in the writ petition was for direction to the respondent authorities, namely the ONGC, for modifying or amending the existing promotion policy and granting promotion of class Roman 4 fireman employee to class Roman 3 fireman employee or higher classes. However, at present, he submits that his prayer is limited to a direction to the respondent authorities to expeditiously consider and dispose of the representation preferred by the petitioners at page
140.
on 1st of May 2018, which has remained pending. Stop. The counsel for the petitioner submits that this application representation, although preferred in 2018, no communication of any orders passed on the representation made by the petitioners has been forwarded to the petitioners. Stop. As per information available to the petitioners, this application has been forwarded by the regional, what do you call it? Regional authorities.
In Najira, it is.
Eastern something. Has
It was forwarded by the state authority, local authority at Najira, ED, ONGC, Assam Assets, Eastern Region, Najira.
It is submitted that the
Respondent number 6.
authorities, the respondent number 6, namely so-and-so, has forwarded the representation
To respondent number 3,
to the respondent number 3.
ED, Chief HRD, ONGC, Dehradun.
Thereafter, no further communication has been received. Stopped. Whereas Mr. D. Sokia, senior counsel representing the respondents, although raised the objection with regard to maintainability of the writ petition on the ground that the issues raised are strictly barred under the Industrial Disputes Act of 1947 and on the judgments which he proposes to press into service. However, in view of the limited prayer of the writ petitioner that the representation preferred by the petitioner should be disposed of, he does not raise any objection to that limited prayer only.
Keeping the issue of maintainability open for inappropriate cases.
That will always be open.
Always be open.
No, but that observation, because otherwise he will come and he will say,
I'll definitely
Since-
come, my lord.
Since
I have the, my lord.
since the primary issue with regard to issuance of directions to the respondent authority for
disposing of.
for modification of the policy is not being urged before the court at present, and no orders to that effect it will be required to be passed by the court. He submits that the question of maintainability will be raised at the appropriate opportunity, as if and when the petitioner approaches this court in response to the prayers made originally in the writ petition. Stop. Where having heard counsel for parties and upon careful perusal of the regulations, considering the limited prayer made by the petitioner, that his representation at page number 140, dated so and so, has remained pending, and for which the respondents have no instructions as on date. This court disposes of the writ petition, directing the respondent number 3 to expeditiously consider the same and pass appropriate orders disposing of the representation within a period of
30 days.
30 days from the date of receipt of a certified copy of this order. Stop. If in the meantime, the respondent 3 had already passed any order, the same shall be served on the writ petitioner. So, with the above observation, without commenting anything on the merits, without expressing any opinion on the merits of the case, the writ petition stands closed, disposed of.
Highly obliged.
Interim orders, if any, stands vacated.
I'll be submitting my representation before the respondent number 6.
No, he had already filed.
140.
No, the certified copy I have to submit, my lord. From the date of receipt of the certified copy, I'll be submitting it before respondent number 6. Otherwise, those are in the Delhi. My lord.
There are-
The certified copy of the order is permitted to be served on the respondent number 6, who will in turn will forward it to the authority before whom the respondent, the representation is pending, namely respondent number 3.
3.
The respondents are also permitted to serve a copy or certified copy of this order before respondent number 3, if they choose to.
Lots.
Disposed.
Highly obliged.
There are these 3 matters are same.
Same. Same. All these 3 matters are same.
So this was same only lots of in item number 3 lordship. Petitioners are presently working as fireman grade 3.
And the others?
In the other last section of it, they are working as deputy chief fireman also.
Representation did.
So item number 3, item number 2, they are working as
Fireman grade 2.
grade 2. लिखिलो. Item 3, they are working as deputy chief.
Item 3, fireman grade 3.
Fireman grade 3. And number 4 is deputy chief.
Deputy chief fireman.
Deputy chief fireman. Okay.
Whether their representation date is same or not.
Same.
Same date.
Same date.
Same.
Highly obliged.
I think by
May I please your lordship? Lordship, kindly pass over the matter for time being, your lordship.
What the time being?
three,
Hey, team of those. Take them on YouTube. That's my proposal.
May I please, Lordship? In earlier occasion, I did from board, Lordship. I withdraw my Kalatama, Lordship.
Huh?
I withdraw my
Before
Kalatama.
he's withdrawing, the last
You are appearing for?
Earlier occasion, I appeared for the board, Lordship.
The
Board
last
is a
order-
necessary party, Lordship.
last order 28th July, my lord.
And my friend will appear in this case.
Lordship, I have been engaged in this case as a for the respondent number.
We will just come in 2 minutes.
Yes, my lord.
Please.
Petition, my lord. In the light of order passed by this earlier 23rd June 2025.
Yes.
May I submit, Lordship? Lordship, I have been newly engaged in this case. Yesterday, we have filed our wakalatnama. So 2 weeks time may be given for. taking
Where
proper
Where is
instructions.
Mr. Chakraborty?
Yes. No time to withdraw from the board.
You can't withdraw. We had issued a direction to you. You
Board
can't
is a
withdraw,
necessary
you
party,
can't
Lordship.
withdraw unless we permit you to withdraw.
Lordship, the board is a necessary party, Lordship.
Whatever it may be, have you read this
On
order?
occasion, I appear for the board, Lordship.
Have you read the order? Did you file for a correction of this order?
I read, Lordship.
Did you file any application that this order needs to be corrected? No.
No.
This order is very clear. We direct the government advocate to place before the court the proper audited reports. You can't come up and say that
Lordship,
we are directing you. You are the government advocate.
I have not received any instruction, Lordship. Lordship.
That you say, but you can't say that you are withdrawing it in the face of the specific order passed by the court.
Lordship, in my submission, we have, the board has paid 2 lakhs rupees already.
We don't want that. We want the compliance of this order. Tell us when you can do it, or we are drawing up contempt proceedings against your clients.
Lordship, I may be allowed to take some instructions before.
You give us a date,
2 weeks time,
not 2 weeks. Next Tuesday,
next Tuesday.
you produce your records. And you inform your clients in no uncertain terms that if we don't find these orders, we are proceeding in contempt against them.
Right, yeah.
Have you understood?
Yes.
All right. Heard Mr. P.K. Dega, Learned Counsel for Party. Petitioner, Mr. A. Chakraborty, appearing for the government. And what is your name?
H. Talukdar. for
Mr. H.
respondent five.
Talukdar, appearing for
Respondent 5.
Respondent 5. By the earlier order, dated 28/7/2005, the government advocates who had entered appearance before the court, namely Mr. A. Chakraborty, was directed to place on record the decision stated to have been taken by the municipal board, on the basis of which it was decided that the balance amount of 5,54,000 shall be paid at the rate of 25,000 per month, which is contrary to the directions contained in the earlier order dated 23/6/2025, passed by coordinate bench of this court. This court had also directed the government advocate to place before the court the proper audited reports showing the fund position of the Nalbari Municipal Board. Whereas today, when the matter is called up, Mr. Chakraborty appears before the court and submits that because instructions have not been received, he seeks liberty of the court to withdraw his power. So, Mr. H.
Talukdar.
on the other hand, Learned Counsel, appears before the court and submits that he represents the municipal board. So, when the court has issued a direction to the respondents permitting the government advocate to produce the records, it was a duty of the respondents to take proper note of the order, and in deference to the order, the records ought to have been handed over to the government advocate for production. Stop. It appears that the respondent authorities have deliberately and persistently flouted the orders of the court, directing which contain the specific directions, including the directions contained in the order dated 23/6/2025, as well as the order dated 28/7/2025. Stop. Such behavior of the respondents is strongly deprecated. Stop. But for the submission made by the council, who represents the Nalbari Municipal Board today, Mr. H. Das, that he has been engaged to appear in the matter. When were you engaged?
Yesterday.
Yesterday. Have you filed your power?
Yes. We have filed it yesterday.
And he has filed his power yesterday. This court would have proceeded to draw up contempt proceedings against the respondents for willfully violating the orders passed by the court. Prima facie, the court is of the view that the respondents Nalbari board. Its action of not complying with the directions are contumacious. Stop. However, in view of the submissions made by the newly engaged counsel, Mr. H. Talukdar, we direct that the matter be listed again on next Thursday. We are giving you time till Thursday, 28th. 28th
28.
of August to produce the relevant records as directed by this court, including the decision taken by the municipal board to pay the balance amount at the rate of rupees 25,000, as well as the proper audited records and reports showing the fund position of the Nalbari Municipal Board. Stop. It is made clear that if the directions are not complied with, the court will proceed to issue consequential orders by the next date fixed.
Not so much.
Let a copy of this order be marked to the office of Senior Government Advocate for onward communication. Yes, 28th.
Yes.
28. Highly of this.
Item 7.
Yes.
Appointment of arbitrator. We've already submitted my lord. Then we have issued an notice also. my lord.
What is your objection here?
They have not approached the scope, my lord, the appointing authority, my lord.
Appointing authority.
As per the agreement, my lord, we cannot, my lord, appoint the arbitrator, my lord. It is a scope, my lord. As a institution, my lord, who can appoint the arbitrator, my lord.
Where are the relevant rules?
Yes, ma'am. I'm already start from my lord. Page 215, my lord. Annexure 13, my lord, page 213, my lord. The object has been given in 214, my lord. Object the scope, my lord. May I read, my lord? The object, my lord.
Hmm?
214, my lord. The object of the scope, my lord.
200?
14, my lord. 214, my lord.
Hmm.
The main object of the scope, forum of conciliation and arbitration. I got it,
Yes.
to serve in settling dispute between the public sector enterprise and their associates with the shortest possible time at more economical and cheapest cost in comparison to other institutions. Forum has retired judges of Supreme Court, High Court, retired secretary and joint secretary, government of industry, executive directors and senior officials of PSC, beside advocates, CS, and other professionals as conciliator and arbitrator on its panel. Now, my lord, next page 215, my lord. This talks about by the conciliation. Now the arbitration is at page 235, my lord.
Yes. Oh.
Now, my lord,
Yes.
page 242, procedure for arbitration proceeding, my lord. Plus it.
Hmm.
The party initiating arbitration shall send to the other party, here the BP segment, a written invitation to arbitration under these rules briefly identified in subject matter of the dispute. Thereafter, that is important, the party would approach the scope forum conciliation matter for arbitration along with the payment of registration fees as per clause 23. And this was not done, my lord. The second part.
Which party?
The petitioner, my lord.
Where is that it say so? Says party.
The
Party
party initiating
initiating
arbitration.
arbitration
Yes, my lord.
shall send to the other
Other
party.
party, a written invitation to arbitration.
Hmm. That's
And-
all.
This is done, my lord. Then thereafter, my lord,
Hmm.
briefly identifying the subject matter of the dispute.
Why,
Thereafter,
why don't you refer it to scope? Yes.
but they have raised a dispute, my lord.
What is the object of scope?
Yes, my lord.
Kindly read your objects.
Yes, my lord.
Read the first line.
The main object of the scope forum of conciliation and arbitration is to serve the settling dispute.
Hmm.
Now, my lord, the dispute has been arisen by the petitioner, my lord, not
That's
by
right.
us, my lord.
That's right.
But there are other
only-
clauses, my lord.
only-
I'll show, my lord.
only-
There are other clauses, my lord. I'll show, my lord.
On the technical ground that he has
No,
not
ma'am.
approached. This is only a forum for having
Yes,
the
ma'am.
arbitration.
Yes, my lord.
Then-
Now, my lord,
Has
it is a-
21 notice been given to you?
yes, thereafter, my lord, they have to approach the scope, my lord. Clause 20, my lord, kindly see, my lord. But I have also discussed the Mr. Biswas also on the day, my lord.
Hmm.
Now, clause 20, my lord, kindly see, my lord.
Where is clause 20?
Page 245, my lord.
$245.
Initiation of arbitration proceeding,
240,
245, my lord.
245. Yes.
Clause 1, my lord, unless there is provision in the agreement between the parties for initiation of arbitration proceeding, a party wishing to have recourse to arbitration proceeding under these rules shall submit its request for arbitration to the secretariat of the forum with a copy to the other side. This was not done, my lord. Then, but the secretariat of the forum shall notify writing to the claimant and the respondent.
Why have you not filed it in terms
My
of
lord,
the-
your losses may see, my lord, first
Hmm.
thing, my lord. If your losses see page 31, my lord.
Yes.
Page 31, the clause is, my lord, any dispute or difference whatsoever arising out of or in connection with this agreement, including any question regarding the existence, validity, construction, interpretation, application, meaning, scope, operation, or effect of this contract, or termination thereof, my lord, this termination word is also there here,
Hmm.
shall be referred to and finally resolved by the arbitrator as per procedure mentioned below. The dispute differences shall, in the event, referred to as sole arbitrator. Now they have only said, my lord, the appointment arbitration proceedings shall be conducted in accordance with the scope foundation. I would not know, my lord, nothing is given, only this second word. And we have issued a notice to them, my lord.
No,
And this,
Are you saying that this was not available with you?
no, well, they is not available, they have not given it. And moreover, my lord, this arbitration clause is not as per this, my lord, 235, your losses, you see. At 235, my lord, the clause is given. Paragraph 3, 235.
Hmm.
The scope forum of conciliation and arbitration recommends all parties desirous of making reference to arbitration by this forum shall provide the following arbitration clause in their existing and future context if law applicable does not prohibit the reference. This clause is not there, my lord. If your lord will see. This clause is absolutely different, my lord. How it will apply? It will not apply. But and this termination is not there in the scope forum.
In your case, it was termination.
Termination, my lord. Now. Now they have terminated also.
Now terminate.
Now terminated.
But
Yes.
now terminate, my lord.
Yes, my lord, later on, my lord, long back.
Prior to termination, my lord, this notice was issued, my lord.
No, it may be, my lord, but now it is terminated.
Where is the notice?
Yes, my lord.
Notice is, my lord, that page 114. At that time, my lord, the matter is pending with the High Court. 114.
No,
It
just pending before the second judgment.
Session judge. Maybe. I was not there.
Any reply to this notice?
No, my lord.
There is no reply.
Yes, my lord.
Then,
But at the same time, they have to approach the scope, my lord. Because the appointment can be
No,
done by the
no.
only scope, my lord.
your clause is very clear here. Page 31 is the clause.
Yes.
Yes, my lord.
Good. And the jurisdiction of the court arises on section 11(4), arbitration.
No, but the 11(6) minus subsection C will come, my lord. Kindly see section 10 first of all, my lord.
Hmm. Yes.
The parties are free to determine the number as arbitrator, provided the such number shall not be an even number.
It is decided.
Yes, my lord. The scope will,
No. Come to
yes,
19A.
the sole arbitrator, my lord.
Sole arbitrator.
Yes, in the scope also, my lord, there is a provision for
You
appointing
first come to
sole arbitrator, my lord.
you first come to your agreement.
Yes, my lord.
The basis of the reference to arbitration for the application of the 11th flows from 19.
Yes, but this is the agreement, my lord.
Ah.
This is the agreed terms, my lord.
Right.
There is also agreed terms that the appointment of the
No,
arbitrator
let
will be
us
done
we'll
by
go
the
into
scope, my lord.
that. Why don't you go step by step?
Yes,
This is your agreement.
Yes, my lord.
There is a reference that it shall be referred to the sole arbitrator,
Yes, my lord.
right?
Yes, my lord.
Then come to 11.
Yes, my lord. 11(2), my lord. Subject to subsection 6. For a moment, kindly see, my lord, subsection 6, my lord.
Hmm.
Where under the appointment procedure agreed upon by the parties, a party fails to act as required under the procedure. B, the parties or the two appointed arbitrator fails to reach an agreement is expected to them, it will not come. Then
You're reading from
11(6), my lord.
11(6).
6, my lord, subsection C, my lord.
Where is the reference to section 6?
Yes, my lord. Section 2, subsection 2, my lord. 11(2), my lord. It says, my lord, subsection 2, subject to subsection 6. The parties are free to agree on a procedure for appointing the arbitrator or arbitrators.
Was the scope agreement, was the scope conditions a part of the agreement?
Yes, my lord.
Where? Where is it referred to?
Clause 19, my lord.
Was a copy served to him?
Agreement he signed.
But the agreement he has signed, my lord.
He has signed.
But it is
Then
available, my lord.
it must be a part of the agreement.
Yes, my lord. It is a part of agreement, my
You
lord.
can't How do you say it is a part of the agreement? If it is, show us from your records that it is a part of this agreement. You have mentioned something that it has to be according to scope.
Yes, my
All
lord.
right, the procedure is according to scope.
Yes, my lord.
But how the arbitration will be referred is governed by these clauses.
But the appointment will be done by the scope, my lord. It is a agreed terms, my lord.
No, where are the agreed terms? That's what we want to
Section
know.
clause 19C, my lord.
Where is
Appointment and a procedure to be done by the scope, my lord.
19B is the seat of arbitration is in Kamrup Metropolitan. 19B,
Yes, ma'am.
it says appointment and arbitration shall be conducted in accordance with scope.
The appointment and arbitration proceedings shall be conducted in accordance to the scope, scope forum of arbitration rules for time being in force or as amended from time to time.
No.
Then seat of arbitration shall be it as per my lord, clause 20, section 20, my lord, this is seat of arbitration.
That's it. Where does it say, where in the agreement does it show that you will have to refer to the scope again? The section 21 is the beginning initiation of the arbitration
No, my lord,
proceedings.
that will not come, my lord, but for my understanding, my lord, I am referring a judgment, my lord.
Yeah, please do.
Yes, my lord.
Yes.
That is by 2007, 5 SCC 703, my lord, which holds the field as of now, my lord.
Yes.
There are 3, my lord. The facts had been given, my lord. May I read, my lord?
Yes.
The Appellant Indian Iron and Steel Corporation Limited, having registered office at Kolkata, invited tenders on 17/22/2003 for transportation of pig iron and steel material from the Banpur, Kolkata stock yard to different customer locations in the various parts of the country. The tenders submitted by the respondent Messrs. Tiwari Road Lines was accepted and a tender was issued on 14/5/2003. Awarding the contract to be respondent to the transport material with effect from so and so for a period of 2 years. The tender was submitted by the respondent at the head office of the company at Kolkata, and the agreement was also signed between the parties at Kolkata. In terms of the agreement, the respondent furnished a bank guarantee so and so. According to the appellant, there was a failure on the part of the respondent to comply with the terms and conditions of the agreement, and according to the appellant, invoked the bank guarantee so and so. Feeling aggrieved by the encashment of the bank guarantee, the respondent filed an application before the Chief Judge City Civil Code Hyderabad, who was the designated authority under 11 of the Arbitration and Conciliation 1986 under the scheme framed by the Honorable High Court for appointment of the arbitrator to decide the dispute between the parties. The appellant contested the application on 2 grounds, namely that the City Civil Code at Hyderabad had no territorial jurisdiction to enter in the application, and secondly, under the terms of the agreement between the parties, the dispute had to be resolved in accordance with the rules of arbitration of Indian Council of Arbitration, and the application filed under section 11 of the act was not maintainable. This is the issue, madam. The City Civil Code Hyderabad allowed the application by order the so and so and appointed a retired judicial officer as arbiter to decide the dispute. The said order was challenged by the appellant by filing a civil revision petition so and so. The revision petition was allowed and the matter was remanded back to City Civil Code Hyderabad to consider the question of jurisdiction. The City Civil Code again allowed the application filed by the respondent by order the so and so and appointed the retired judicial officer as arbitrator to decide the dispute between the parties. This order was silenced by the appellant by filing a petition in the High Court on the ground inter alia that the application under section 11 of the act was not maintainable, as the agreement between the parties contained a clause that any dispute between the parties shall be decided in accordance with the rules of arbitration and conciliation Indian Council of Arbitration, and the respondent had not taken recourse of the said rules. The other plea taken in the petition was the City Civil Code Hyderabad had no territorial jurisdiction to entertain the application under 11 of the act. The High Court negated the contention raised by the appellant and dismissed the petition. It is these orders who is subject matter of the challenge in the present appeal. We have so and so. Now, the arbitration clause has been given, para 5. After tender of the respondent Messrs. Tiwari Road Lines had been accepted, an agreement was executed between the parties, which contained general condition of contract for transportation of iron and steel materials and pig iron from the Banpur and Kolkata to various destination in India. Clause 13 of the general condition of contract is as under 13.1. All dispute differences whatsoever arising between the parties out of or relating to a construction, meaning an operation or effect of this contract or the breach thereof shall be settled by the arbitration in accordance with the rules of arbitration of Indian Council of Arbitration, and the award made in pursuance thereof shall be binding on the parties. Then a perusal of I'm skip 13.2. A perusal of the 13.1 will show that under the terms of agreement, all dispute differences whatsoever arising between the parties have to be decided by the arbitration in accordance with the rules of arbitration of the Indian Council of Arbitration, and the award made in pursuance thereof shall be binding on the parties. 6.
Yes.
It is not disputed that the respondent did not make any effort to have the dispute settled by the arbitration in accordance with the rules of arbitration of Indian Council of Arbitration. On the contrary, it is straightway moved an application under 11 of the Arbitration and Conciliation Act 1996 before the City Civil Court Hyderabad, which was the designated court in accordance with the scheme framed by the High Court of Andhra Pradesh. The principal question which requires consideration is whether such an application moved by the respondent was maintainable. Subsection 1 to so and so to 7 of the section 11 of the Act read as under on the section 11 has been quoted, my lord. Now, para 7, my lord. I'll go to my lord. Para 7.
Yes.
Subsection 2 of the 11 of the Act provides that subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrator. The opening part of the subsection 3 and 5 of the 11 of the Act uses the expression failing any advert to in subsection 2. Therefore, subsection 3 and 5 will come into play only where there is no agreement between the parties, as is referred to subsection 2 of section 11 of the Act, namely that the parties have not agreed on a procedure for appointing the arbitrator or arbitrators. If the parties have agreed on it by him to take necessary measures can be made. If the condition enumerated in clause A or B or C of the subsection are satisfied. Therefore, recourse to subsection 6 can be had only where the parties have agreed on a procedure for appointment of an arbitrator, but a party fails to act as required under the procedure. B, the parties or two appointed arbitrator fails to reach an agreement expected of them under that procedure. C, a person including an institution fails to perform a function entrusted to him and or it under the procedure. Therefore, combined reading of the various subsection of 11 of the Act would show that the request to Chief Justice for appointment of arbitrator can be made under subsection 4 and 5 of section 11, where parties have not agreed on a procedure for appointing the arbiter as contemplated by subsection 2 of the section 11. A request to Chief Justice for appointment of arbitrator can also be made under subsection 6, where the parties have agreed on a procedure for appointment of arbitrator as contemplated in subsection 2, but certain consequential measures which are required to be taken as enumerated in A or B or C of subsection 6 are not taken or performed. Now, para 8, my lord. In the present case, the agreement executed between the parties contains an arbitration clause, and clause 13.1 clearly provides that all dispute differences whatsoever arising between the parties out of or relating to the construction, meaning an operation or effect of the contract or breach thereof shall be settled by the arbitration in accordance with the rules of arbitration of the Indian Council of Arbitration, and award made in pursuance thereof shall be binding on the parties. This clause is in accordance with subsection 2 of section 11 of the Act. There being an agreed procedure for resolution of dispute by arbitration in accordance with the rules of arbitration of Indian Council of Arbitration, subsection 3, 4, and 5 of section 11 can have no application. The state for invoking subsection 6 of 11 has not arrived. In this circumstances, the application moved by the respondent before City Civil Court Hyderabad, which was a designated authority in accordance with the scheme framed by the Chief Justice of the Andhra Pradesh High Court, was not maintainable at all. The City Civil Court had no jurisdiction of authority to appoint an arbitrator. Thus, the order that so and so passed by the so and so appointed retired judicial officer arbitrator is clearly without jurisdiction and has to be set aside. Now, para 9, The legislative scheme of section 11 is very clear. If the parties have agreed on a procedure for appointing the arbitrator or arbitrators as contemplated by subsection 2 thereof, then the dispute between the parties has to be decided in accordance with the said procedure. And recourse to the Chief Justice or his designated cannot be taken straight away. A party can approach the Chief Justice or his designate only if the parties have not agreed on a procedure for appointing the arbitrator as contemplated by subsection 2 of section 11 of the Act, or the various contingency provided for subsection 6 have arisen. Since the parties here had agreed on a procedure for appointing an arbitrator for settling the dispute by arbitration as contemplated by subsection 2, and there is no allegation that any one of the contingency enumerated in clause A, B, or C of subsection 6 had arisen, the application moved by the respondent herein to City Civil Court Hyderabad was clearly not maintainable, and said court had no jurisdiction to entertain such application pass any order the order so and so therefore is not sustainable. Here also, my lord,
Yes.
the procedure has been laid, my lord.
According to the procedure, who will be the arbitrator?
Yes, my lord. Page 239, my lord.
Hmm.
Panel of arbitrator, my lord.
Yes.
The secretary, in consultation with two members of the governing body, shall prepare and maintain a panel of arbitrator from amongst the person qualified and or possessing knowledge or experience in their respective field or profession or arbitration law, procedure, and person of integrity, impartiality, willing to
You
serve.
show us the panel of arbitrators?
Yes. Clause 8, my lord.
Hmm. Clause?
Clause 8, my lord, page 240. This is a person to be appointed by the ISCO, my lord.
Who are your panel?
But the secretary will, my lord,
You get it?
yes, ma'am. The retired judge of the Supreme Court of India, High Court, deceased judge, or officer of the higher judicial service and equivalent. Now,
Where is the panel?
but the panel will form by the ISCO, but the secretary will form, my lord, after getting approval from the governing body, my lord.
Your section, your clause 7
7, my lord.
shall prepare and maintain a panel.
Yes, my lord.
So it must be in existence.
Yes, my lord. The ISCO will disappear. Here, my lord, the ISCO was not made,
No, no.
made as a party also, my lord.
No, what is the scope? What is it?
Yes, my lord.
What is scope?
Yes, my lord.
What is the
Full-
nature of
yes,
the
yes, yes, yes,
organization?
there is, my lord, 237, my lord, is 240, my lord.
What is
ISCO
scope?
means, my lord,
Hmm.
237, my lord. It means, my lord, standing of conference of public enterprise registered under so and so, my lord.
So what is it?
Standing conference of public enterprise registered under the Registration Society Act so and so, having registered office as ISCO complex.
Therefore, what is it? Is it a society?
It is a
Is it-
society, my lord, under
Huh?
the society. Registration.
How do you, on what basis are you making this statement? What is it? What is the nature
My-
of scope?
It's an institution, my lord.
What is this ONGC? Who are you representing?
My BPCL, my lord.
BPCL.
Yes, my lord.
Is the BPCL signatory to all this?
Yes, my obviously, my lord. The object will clarify, my lord.
Hmm.
Now, my lord, the scope also, my lord, the forum has also, my lord, take care of the 12.5 also, my lord.
Hmm.
Take care of the provision of 12.5 also, my lord. Disclosure part also has been given, my lord. Clause 11, my lord, 241, my lord.
But what is scope?
Is an institution, my lord,
Where is this? Where is its office?
in Delhi, my lord.
In Delhi.
Yes, my lord.
Where was the agreement executed?
Here, my lord.
Here.
Here, my lord.
So you want the
No, my lord. They can also sit, my lord. The venue can be remain in the Guwahati also, my lord. Yes,
Venue
there's a
is all
clause, my
right.
lord. There's a clause, my lord.
No, venue is all right.
Yes, my lord.
Venue comes only once the arbitrators are appointed and they commence on the arbitration.
Yes, my lord.
Here is a scope.
The
Here
place
is
of
the
arbitration.
question of appointment.
Yes.
So for you are saying that they'll have to approach the scope.
Yes, my lord.
Where? In Delhi.
Delhi, my lord. The address is there, my lord. Now, my lord,
No, so in essence, what you're saying is that the arbitration
Yes,
clause,
clause 21, my lord, kindly see, my lord.
clause 21 of?
Yes, my lord. The scope, my lord, page 246.
Yes.
In the agreement, my lord, the seat of arbitration is at my lord, Guwahati, my lord.
No, clause 21 says it is in Delhi or otherwise.
No,
agreed.
Unless there is a provision in the agreement
Hmm.
or otherwise, but the agreement, my lord, is
Hmm.
shows, my lord, Guwahati, my lord.
No, that is all right.
Is agreed by party.
Now, you say that they'll have to approach scope.
Yes, my lord.
Does the scope has an office here in wherever the agreement is executed?
In
There will
Guwahati,
be
there is no,
representative.
it is in my lord, Delhi, my lord.
So a person
by-
will, person will execute an agreement with you
Yes, my lord.
in Assam.
Yes, my lord.
As and when the dispute arises, you force him to go to Delhi.
But they can send their dispute, my lord, through email also, my lord.
We don't know. You say that, you bring it on record to
Yes,
show
my
that
lord.
this is what is the procedure.
Clause 20, my lord.
Otherwise, you are frustrating the very
No,
the agreement
Clause 20, my
arbitration
lord.
clause
Clause 20, my lord.
of.
Of the scope, my lord, 245.
No.
Is not the, my lord, the person will personally go to scope, my lord.
Later we'll do. Just like this.
Complete procedure has been given, my lord.
This is the procedure.
Yes, my lord.
This is the conciliator has to be appointed.
No, my lord, the clause 20, my lord, 245, my lord.
Huh?
245, my lord. There are two parts, my lord. First one is conciliation, second part is, my lord, arbitration, my lord.
245.
Yes, my lord.
Yes.
The word communication has been given, my lord. You know, there was some 88.
What do you say about section 21?
But 20 will not come, my lord. The word has been used, my lord.
Hmm.
It is not, it comments, my lord. Unless otherwise agreed by the parties.
Hmm.
The default provision is there, unless otherwise agreed by the parties, my lord.
Hmm.
The arbitration proceeding is expressed a particular dispute comments on a date on which the request for that dispute.
Where have you agreed with regard to the notice in your agreement
But
or in the scope? In the
Plus-
scope,
plus 20, my lord.
clause 20.
Yes, my lord.
Yes.
Now the, if my lord, scope will fail to appoint the arbitrator, my lord,
No, no, no.
after receiving the notice, my lord.
See, 21 is not only for 11.6.
Yes, my lord. The commencement of the arbitration, my lord.
21 is where you have an agreement for
Yes, madam.
arbitration and the aggrieved party issues a notice.
Yes,
on
my
you.
lord. Yes, my lord.
So the arbitration has commenced.
Yes.
Now, in the scope, is there anything to suggest as to how this 21 notice is to be issued? Who is to issue it? What will be the
Now, my
effect
plus
of?
20, my lord, I'm trying.
Hmm.
I'm married, plus 20 minutes again. Initiation of arbitration proceeding. Unless there is a provision in the agreement between the parties for initiation of arbitration proceeding, a party wishing to have recourse to arbitration proceeding under these rules shall submit.
That is not 21.
Yes, madam.
No, that is not 21.
Yes.
And in any case, assuming you are referring to 20,
Yes, madam.
that it replaces 21, it will amount to replacing a statute
No,
with an agreement.
clause 16, my lord, it says, my lord, the party who wishes to, my lord,
No, no, I
Take
agree
recourse.
with that.
Yes,
We
ma'am.
we are asking you the implication of section 21. 21 is not only for 11.6.
yes, madam, is commencement of arbitration proceeding, my lord.
Commencement of arbitration.
Yes, that's
So once it is commenced,
yes, madam.
you do not reply to the notification. You don't reply to the notice.
Yes, madam.
Nor do you, or you have chosen not to send it to scope.
Yes, madam. Because dispute, he has a,
Whatever,
yes,
but
madam.
are you saying that you are not even required to reply to it? Which means by your position, you are admitting that there is a dispute.
Now, my lord, by going to records, I cannot say, my lord, too much, my lord. Clause 16 says, my lord, there are two-tier system, my lord.
Huh?
First, in clause 16, my lord, 242, my lord, a
Hmm.
two-tier system, my lord. First, the person who raises a dispute, my lord,
No,
he
no,
has
this is with regard to
to
the
appointment of
procedure.
arbitrator, my lord.
This is with regard to the procedure.
Yes, my lord. The appointment, my lord.
You as a public sector, you have chosen to have a forum for arbitration,
Yes, my lord.
right?
The appointment in the procedure to be done by the, my lord.
No, this is your choice.
No, not our choice, my lord.
It is the choice of the
It is
public
agrees
sector.
choice, my lord. It's not our choice only. my
It
lord.
is the choice of the public sector undertaking to be a part of scope.
No, but it is.
Therefore, you have incorporated this in your
Yes, my
agreement. All right. Now, this is with regard to appointment procedure, etc.
Yes, my lord.
Now, in the absence of any reply
Yes, my lord.
from your end to a notice under 21, what will be your position? What will
Now,
be the
at the
effect
same,
of section
that's what
21?
I am saying, my lord. At the same time, my lord, once, my lord, person has issued a notice under section 21 to the other party, my lord, as per the scope, my lord, at the same moment, my lord, he has also sent a copy to the scope, my lord. Clause 16, my lord,
16 of?
245, 242.
Hmm. All right, but
Assuming, my lord, the section
the fact
21, my lord,
remains,
yes,
the fact remains,
yes, my lord, the fact remains, my
the
lord,
fact
the
remains that
notice
the
has been issued, my lord.
arbitration proceeding has been initiated under section 21.
Yes, my lord. Even then, my lord,
It could, no, it's not even then. It's a mandate of the statute.
yes,
Section 21 says commencement on the issuance of notice.
issuance of notice, my lord.
You have a right to either disagree that there is no dispute. There could have been one situation where you disagree and say that no, there is no dispute,
Yes,
according to you.
yes, my lord. It is in the, my lord,
It is possible that you may resort to some other communications to say that, all right, we are trying to resolve the dispute, no arbitration at this stage. Or you could have very well said that no, arbitration will only commence as per procedure of so and so, but nothing comes up.
Yes, my lord.
Now, in that view of the matter, are you saying that assuming 16 is not followed or any other clause is not followed, 21 will not be applicable?
Because the, my lord, in 21, my lord, the default part is there, my lord, unless otherwise agreed by the parties, my lord.
Unless otherwise agreed.
Yes, my lord.
Yes. But the question is that
Yeah, they have agreed, my lord, that the
no,
procedure, procedure will
no.
follow, my lord.
The unless otherwise agreed part will come specifically
Also, I am trying to, my lord, learn, my lord. First,
only when you agree
yes, my lord.
that assuming you give me a notice,
Yes,
you can have any other conditions there
yes,
that notice has to be accompanied by such and such documents, or you have to send
Yes.
copies, etc., whatever you
yes, two tier system.
whatever procedure you agree.
Yes, my lord.
It is only to that limited extent. It is unless otherwise agreed by the parties.
Yes,
Or you may say that the arbitration process will commence only when the matter is referred by scope. You could have had it in the agreement. Notwithstanding 21,
yes,
since we have agreed to refer it to scope,
yes,
proceedings will commence only when scope initiates the arbitration.
That is not there.
It's not there. So therefore, unless otherwise agreed, you
Yes.
did not agree to that.
Yes, ma'am.
So therefore, unless otherwise agreed, arbitration proceedings will commence
Yes.
on the date on which a request
Yes, madam.
is made. So the request has been
Here,
made.
here, my lord, the slightly defined, my lord. To my understanding, my lord. Here, my lord, the procedure for appointment has been given to scope, my lord.
You are going back to the same argument.
Yeah,
See,
obviously, madam.
you are referring to the scope,
Yes, my lord.
but you choose not to reply to the 21 notice.
Yes, my lord. Admittedly, my lord, there is no reply.
According to you, 21 notice will not apply unless he initiates the proceedings and the scope.
And I'm not saying so, saying so.
So what are you saying?
If I'm a retired, my lord. See, my lord, the appointment procedure, the appointment has been given to the scope, my lord. I'm retired.
There is no confusion on that.
Yes, my lord. Without exhaustion, is that remaining, my lord?
Is it your argument to say that because the appointment procedure is laid down,
Yes, my lord.
it will override the requirement under
No,
21?
no. Obviously not, my lord. For a moment, my lord, we have not given the reply, my lord. Does it give him the right, my lord, to approach the Honorable High Court directly, my lord?
We'll examine that, but let us
That is
first.
the issue, my lord.
No. The question is that you choose not to apply.
Yes.
You did not
Admittedly,
invoke
there
your
is no
right.
reply to that
What is
notice given by
the purpose of
petitioner.
21 notice?
Yes,
What
ma'am.
is the purpose of 21 notice? Calling upon the other side
Yes, ma'am.
that this is a dispute.
Yes.
Let us refer it to arbitration as per
Yes.
the agreement.
Yes,
You
ma'am.
choose not to reply.
Yes, my lord. That does not give him a right, my lord.
Whether it gives him a right or not, we'll examine that. But first you'll have to explain the scope and the effect of section 21. In view of your argument that the entire procedure is laid down in scope, and therefore it is only through scope, and it was his duty to refer it to scope. And
But maybe for a moment, my lord, to my understanding, my lord, the reply has not been given, my lord, to his notice, my lord. That's why I'm questioning myself, my lord. Does it give me a right to approach this Honorable High Court under 11.6, my lord?
that will depend on how you explain the implication of section 21 notice. Are you saying that section 21 is just a section? It has no implication.
It has an implication, my lord.
What is the implication?
It has to be read with scope form.
But it has to be read with, my lord, by scope from, my lord.
That's the agreed term.
It's the agreed terms, my lord.
All right.
The clause is not as per the.
Now, I'm relying on others as well, my lord, the 2008, my lord.
Yes, give us. Yes.
Yes, madam. But it is about 2008, 10 SCC, page 240, madam. 240? 240. Is said by three judge bench, madam. Married, madam.
Yes.
Para 2, madam. Noticing two different views in the two decisions of this court in so and so. SCA Pipeline Context Private Limited versus Bharat Petroleum Corporation Limited and Indo India versus Bharat Battery Manufacturer. So the matter had been referred to a larger bench, and this is how these cases are before us. In both the decision on the question related to appointment of arbiter under section 11.6 of the Arbitration and Conciliation Act so and so. In Bharat Battery case, the earlier decision of SC Pipeline case was apparently not brought before this bench, as a result of which there appears to be some confusion. As noted above, the scope and ambit of the 11.6 of the Act relating to appointment of arbitrator falls for consideration in these cases. 4. The extent of Mr. Horace and Salve appearing for the sum of the parties in this appeals and Mr. B. Additional Solicitor General is that the true scope and ambit of 11C has to be considered in the background of the section 28(3) and section 34 of the Act. 34 2B says, it can be challenged if the procedure has not been made constituted. In the agreed procedure referred to subsection 2 of 11 has an exception in subsection 6 where the agreed procedure fails, where there is no agreed procedure, subsection 3, 4, 5 of section 11 apply. 5. It is pointed out that there is 3 clauses in subsection 6 of the section 11. Clause C relates to failure to perform function entrusted to a person, including an institution. But this step has not even come, my lord. Also, failure to act under the procedure agreed upon by the parties. In other words, clause A refers to parties to the agreement. Clause C relates to a person who may not be a party to the agreement, but also a given consent to the agreement. It is also pointed out that there is a statutory mandate to take necessary measures unless the agreement of appointment procedure provided other means of securing the appointment. It is therefore submitted that before alternative is resorted to, agreed procedure has to be exhausted. The agreement has to be given effect and contract has to be adhered to as closely as possible. Corrective measures have to be taken first, and then the court is the last resort.
Yes.
6. It is also pointed out that while appointing an arbitrator in terms of subsection 8 of the 11, the court has to give the due regard to any qualification required for the arbitrator by agreement of the parties and other consideration as are likely to secure the appointment of an arbitrator, independent or impartial arbitrator. It is pointed out that both these conditions are cumulative in nature. Therefore, the court should not directly make an appointment. It has to ensure first that the provided remedy is exhausted. The court may ask to do what has not been done. But here, my lord, in the present case also, my lord, the step is yet to come, my lord. In response, Mr. Ashok Desai, learned senior counsel, appearing for the sum of the parties who have sought for appointment of arbitrator, submitted that the expression due regard relates to some of the factors which have to be considered. It is not mandatory that the qualification and the consideration are referred to in subsection 8 of 11 perforce have to be applied. It is the question of degree on the parameters of the consideration. With reference to early, I'm skipping 8 and 9, but it talks about the section 11. Now, para 10. The crucial subsection are subsection 2, 3, 4, 5, and 6. Subsection 3 to 5 refers to cases where there is no agreed procedure. Subsection 2 provides that the subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrator or arbitrator. Subsection 6 sets out the contingency when party may request the Chief Justice or any person of institution designated by him to take necessary measures unless the agreement on the appointment procedure provided other means of securing appointment. The contingency contemplated in subsection 6 essentially are the party fails to act as required under the agreed procedure, or the parties or two appointed arbitrator fails to reach an agreement expected of them under that procedure. 3 is important. A person, including an institution, fails to perform a function entrusted to him or in under procedure. In other words, the third contingency does not relate to the party so and so. 11. The crucial expression in subsection 6 is a party may request the Chief Justice or a person or institution designated by him to take the necessary measures. The expression has to be read along with the requirement in subsection 8 that the Chief Justice or the person or institution designated by him in appointing an arbitrator shall have due regard to the two cumulative conditions relating to qualification and other consideration as are likely to secure the appointment of an independent and impartial arbitrator.
Yeah.
12 minutes. A bare reading of section 11, scheme of section 11 shows that the emphasis is on the terms of the agreement being adhered to and given effect as closely as possible. In other words, the court may ask to do what has not been done. The court must ensure that a remedies provided for are exhausted. It is true, as contained by the Mr. Desai, that it is not mandatory for a chief justice or so and so designated by him to appoint the name arbiter, but at the same time, due regard has to be given to the qualification required by the agreement and other consideration. So, my lord, the first of the party has to exercise the remedy provided in the agreement itself, my lord. If the my lord, institution or the person fails to perform his duty, my lord, then he can approach this honorable court under 11.6, my lord.
But it doesn't answer the question put by the court.
Section 21 of the appointment of
He talks about the commencement of the arbitration, my lord. It doesn't relate to my lord, appointment of arbitrator, my lord.
procedure.
It only commencement.
Yes, my lord. The appointment has been, procedure and the appointment has been given to the scope, my lord.
It takes care of limitation 21. Limitation. Even
Then, my lord, from the day of my lord, issuance of not the limitation will come, my lord.
even limitation. But arbitrator has not yet been appointed.
Yes. Anything more?
Not yet appointed.
Yes, Mr. Bottom.
Yes.
Right. (1992) arbitration. I have taken this from Mr. Onam বিশ্বাস, my lord. My lord, para terminal last page, my last but one.
Proceedings,
that
not yet seen done. But we are supposed to.
Now I start with my lord, page 7, my lord. You start the word, my lord, section 11.2, my lord. Section 11.2 of the Act provides that the subject of section 6, the parties are free to agree on a procedure for appointing the arbitrator or arbitration. In the instant case, the parties have agreed to for a certain procedure of appointment of arbitrator. Subsection 6 of to section 11 would operate only if the party fails to act as required under that procedure. The instant case is not the one in which the menace has failed to act according to the procedure. As I have already stated above, immediately by rejecting the appeal filed by the appellant contractor, by finding that there is a dispute, it has proposed a panel of 3 names of the appointment of one of them as the sole arbitrator in terms of the 52.3 of the agreement, and it was only for the applicant to choose any of them as the sole arbitrator, who is the applicant has not chosen to do so. From this, it follows that the applicant wants to give a go by to the procedure prescribed by the arbitration clause agreed to by the parties under clause 52.3. Since the parties are free to agree upon a procedure for appointment of arbitrator or arbitrators, and after such agreement, the applicant is bound to of such agreement entered into, hence the applicant has to follow the such procedure, and it was bound to accept one of the arbitrator from the out of the panel suggested by the menace in terms of so and so. Therefore, the applicant, by refusing to follow the procedure by itself, cannot approach the court under section 11 of the Act. The intendment of section 11 is that if the other side is not ready to follow the procedure, the applicant may seek the High Court for direction to the other side of the either follow the procedure or request the High Court to appoint the one arbitrator in terms of the scheme. In other words, it does not lie in the mouth of the any person to say, I don't want to follow the procedure prescribed under the arbitration clause and appoint one arbitrator for me. He also made the petitioner my lord, have not followed the procedure, my lord.
All right. Yes. Anything? That's all?
Yes. And 25 judgment, my lord, the recent judgment, my lord, 5 judgments, and he says about the unilateral appointment by the parties, my lord. So, my lord, the 2007,
judgment?
8, my lord, and this
Which-
19.
Which judgment?
This central irrigation for railway electrification versus my lord, ECI speaks SMO MCML, my lord. It
7 judgments.
It's 5 judgments. Even page number. 641. 2025 4 SCC 641.
Yes.
My issues has been framed by the larger bench, my lord, at page, my lord, 688, my lord.
Hmm.
Probably my senior produced this judgment, my lord. The issues as my lord, the whether an appointment process which allows a party who is an interest in the dispute to unilaterally appoint a sole arbitrator or create a panel of arbitrator and mandate that the other party select their arbitrator from the panel is valid in law. That is the issue, my lord. That's why I'm saying that the 2007, 8, and 1982, man, still hold the fields, my lord. So far, the my lord,
So
appointment.
what is the finding of the
Yes,
court?
yes, yes. Finding is, my lord, 756, my lord.
Yes.
In view of the above discussion, we conclude that the principle of equal treatment of the parties applies at all stages of the arbitration proceeding, including the stage of appointment of arbitrator. 2. The Arbitration Act does not prohibit PSU from employing potential arbitrator. However, an appointment clause cannot mandate the other parties to select its arbitrator from the panel created by the PSU. A clause that allows one party to unilaterally appoint a sole arbitrator give rise to justifiable doubt as to the independence and impartiality of the arbitrator. Further, such a unilateral clause is exclusive and hinders equal participation of the other party in the appointment process of arbitrator. In the appointment of a 3-member, that is not my issue.
This
170.
is with regard to curated panel.
Yes, madam.
Then
Please. One is there, sir. It's a long judgment, my lord. I just confused, my lord. So, Sobra 11 says is concerned, my lord, para 72 is says, my lord.
yes.
The defining characteristics of arbitration law is that it allows freedom to the parties to select their arbitrator. This is the unlike domestic court of tribunal, where the parties have to litigate their claims before the pre-selected and randomly elected bench of the judges. Section 11(2) of the Arbitration Act allows the party to agree on a procedure for appointment of arbitrator. The procedure contemplated under Section 11(2) is to set an action which party undertake in their endeavor to appoint the arbitrator to execute their dispute independently and impartially. Without formal equality at the stage of appointment arbitrator, a party may not have equally say in the facility appointment of an unbiased arbitrator in the quasi-judicial process, such as also appointment of an independent impartial arbitrator ensure procedural equality between the parties during the arbitration proceeding. That is thus my lord, indicating in this judgment. This is thus my lord, indicating in this judgment, my lord. Nothing more has been elaborated, my lord. So for the procedure and
There are, you have to go through it. There are findings.
yes, but if the 11, 3, 4, 5 had been
No,
boldly
there are
discussed, my lord.
there are findings as to the very concept of arbitration, what
Yes,
is
my lord. The party
extent
autonomy,
of
my lord, public sector.
the referral court,
Yes, my lord.
curated panels.
Yes,
You are
ma'am.
referring to curated panels.
Yes, ma'am.
The other aspects are there.
Yes, ma'am.
If you want to refer to, you can refer.
No.
Yes.
Hello.
Mr. Sarvana?
Well, first thing, my lord, I'm.
Yes, refer to some judgments. Would you like to refer to them or?
No, my lord, not. First thing, my lord, the arbitration clause is not in accordance with the scope, my lord. If you also see page
No, but you have signed it.
my lord,
You have signed it.
no, this clause is not there as part of that, my lord.
May not be, but
No, here termination is not there, my lord. Now they have terminated. I have to raise that point, my lord. That's the main question, my lord. Termination is not there.
you are not putting the clause to challenge before any court.
No, they have not given the, my lord, the rule, my lord, at the time of agreement, my lord. Just only mentioned. Your lordship see the clause at page 235. It was said, my lord. Scope, forum of conciliation and arbitration, 3, recommends to all parties desirous of making reference to arbitration by this forum shall provide the following arbitration clause in their existing and future contract, if law applicable does not prohibit them. So this clause is to be, my lord, incorporated. Well, since they have not incorporated this clause, my lord, so they cannot.
Have you indicated in your notice?
No,
What-
we have,
what-
my lord,
what
at
have
the
you
time we did
indicated
not
in
know, my
your
lord.
notice?
At the time we were no, because they did not know, my lord, about this. They just regular, my lord, personal drive. And they have also not stated, my lord, anything, my lord, after that you have to go to scope.
My lord, page 123 of their notice, my lord. They himself, my lord, stated about this scope, my lord.
120,
3, my lord.
where have you stated?
Oh.
My lord, be it mentioned here that, my lord, the start, my lord.
Hmm.
Clause being the appointment and arbitration proceedings shall be conducted in accordance with the scope forum, my lord.
Yes.
Clause only. 19 has been quoted, my lord. Clause 19 has been quoted only.
Hmm.
That our agreement. Clause 19 has been quoted, nothing more than that. So, unless, my lord, this clause, my lord, as per the scope, this clause is to be incorporated by the party who want to go to for the scope. And this clause has not been
No, but
incorporated.
the agreement 19 also refers to appointment proceedings as per scope.
No, that scope has been, but this, if you also
So
see.
can you say that 19 A, C and D and E are all acceptable except B?
No, first thing, my lord, this, if you also see, scope has, there is in the scope agreement, my lord, if this clause is seen, this, it is totally different, my lord. Totally different. If we go to scope, my lord, the termination is not there.
It may not be there, but in the agreement, in the arbitration clause, there is
Yes.
a reference that appointments, not
That-
only procedure,
No,
appointment
that is there, my lord.
and proceedings shall be conducted in accordance with scope.
Yes.
So how do you deny that you are not aware of it?
No,
Or the scope is not applicable?
only, my lord, first thing, when we have issued the notice, they have not informed us, my lord. That is one aspect.
Hmm.
Secondly, my lord, if your lordship will see page 242, clause 16.
Yes.
My lord, it says, my lord, that the party intimating arbitration shall send a copy to other side, later in addition to arbitration, and they do briefly specifying the subject matter of the dispute. Thereafter, the party would approach, but I do not know whose party is to approach. This is the thing.
Why not the party referring for arbitration? You are the one raising arbitration.
But only thing, my lord, first thing, if suppose, my lord, this is the, if termination is not there, my lord.
All right. Is there anything more? You don't want to reply to the judgments?
No, my lord.
Yes, sir.
That, my lord, you must not fix it another day, my lord.
Heard counsel for parties. List. On 11th. 11th?
Getting 11. No, after 11 minutes, after 12 minutes. What has it been?
16th.
Much.
Preferred is here.
Most 16, my lord, they.
September.
18 नहीं दे रहेगा 16 ठीक है
16.
This is next.
9th my lord
I'm
it may be. It may be your
9 almost. The time is
first week of 6.
9. 11 or 9. 9. I'm Bombila.
16th, any difficulty?
Let it do.
All right.
I'm appearing for item number 8 in this case. Will kindly see the order that was been passed by this court. And there was the interim order. So Lordship looks into that. One of will kindly see the order of 8/1/2025. May I read this order, man? That will clear what is the fact. Then I'll just, 15 minutes, I'll just close it. My lord, kindly see to mine advertisement dated 27/2024. The respondent Indian Oil Corporation Limited invited application for filling up a number of vacancy as non-executive person, including junior engineering assistant for production. Advertisement also indicated a vacancy to be filled up by the said recruitment process. As per the advertisement, 24 number of vacancies have been reserved in the post of junior engineering assistant for production for candidate belonging to scheduled caste category. As per the advertisement, selection methodology comprised of a computer-based test and a skill proficiency physical test. As per the selection methodology, the SPPT would be of qualifying nature. Petitioner respondent said advertisement submitted candidature as a scheduled caste category. Now this is important. As per clause 13.5 of the advertisement, a candidate belonging to categories like SC or ST is required to submit the caste certificate along with the declaration in the prescribed format annexed as Annexure 5 to the advertisement. It is the case of the petitioner he submitted the caste certificate in a prescribed format after obtaining it from the office of the Deputy Commissioner Kamrup Aminga. On the basis of the application submitted by the petitioner was allowed to sit in CBT held on 29/9/2024. CBT was held for a total marks of 100 and the petitioner secured 51 in CBT. The cutoff marks for SC category candidate in the CBT was 47, meaning thereby petitioner has secured the minimum cutoff mark for candidate belong to SC category. Petitioner is aggrieved by rejection of his candidature for the SPPT on the ground that is caste certificate submitted by the petitioner in the prescribed format in Annexure 5, the caste of the petitioner was not mentioned. My lord, that's the issue before this court, my lord.
Yes.
On perusal of the caste certificate issued to the petitioner by the office of DC Kamrup Amingaon on 4/11/2019, your lordship will kindly mark this date. It is seen
that the caste certificate was issued stating that the petitioner belonged to ST category recognized under the Constitution Scheduled Caste Order 1951. Petitioner was earlier issued a caste certificate SC by the Office of Deputy Commissioner Kamrup Amingaon on 30/4/2011, a copy of which has been annexed to this writ petition as Annex 3, wherein the caste of the petitioner is mentioned as Mali. My lord, 2011, there was already a caste certificate whereby the subcaste also was mentioned as Mali. But the issue here in 2019, while with the advertisement which was issued by them, the caste certificate that Mali was not mentioned. Yes, subcaste was not mentioned. That's the issue. That is the reason why they didn't call for SC. That is what is challenge. Now, what is the order passed? Now, kindly see 10. Petitioner has projected that the SPPT is going to be held on 9/1/2025. Learned Counsel of Petitioner has submitted that if the petitioner is not allowed to participate in the SPPT, despite having secured the minimum cutoff mark fixed for the SC category candidate, petitioner would suffer immense prejudice. Fact that the petitioner belongs to SC category subcaste Mali is prima facie evident from the caste certificate issued by the Office of DC Kamrup Amingaon on 30/4/2011. As the advertisement itself has mentioned, the SPPT would be qualifying nature. Recruitment process has been undertaken for filling up 24 number of vacancy for the SC category. SPPT is going to be held on 9/1/2025. Respondent IOC shall not fill up one post of junior assistant for production reserved for SC till the returnable date. So, my lord, kindly see the order passed by this court was on 8/1/2025 and the SPPT which to be held on 9/1/2025. So, the court said that it will go on, but they will keep one post for junior engineering assistant for as a vacant.
You were allowed to appear.
I did not, I was not allowed to appear. Because 8/1, the court said, okay, we will not disturb them. But in the meantime, one post should be vacant. Now, kindly see my writ petition. How I structured the writ petition and how it is presented. If your lordship looks at page 15 of the writ petition, this is my caste certificate issued by the Deputy Commissioner Kamrup. Now, kindly see date 30/4/2011, lordship got on the right hand side on the top and see the subcaste Malik. This is your lordship will note down 2011.
Yes.
Right, my lord? Now, if you see at page 16, next page, this is the advertisement. That is on 27/2024. And my lord will mark it. This is for refinery division, that is A. And you see at postcode at A 201, that is name of post junior engineering assistant for production. Lordship got it? And see on the top, refinery C, Guwahati, total is 19, unreserved 8, 2 is EW, SC is 2, which is one of the petitioners before this court. Now, kindly see page 28, selection methodology at page 28. Now, if your lordship looks into J at page 28, see on down below, J selection methodology 1. Selection methodology will comprise computer-based test and a skill proficiency physical test. SPPT will be a qualifying nature. Now, computer-based test will consist of one object. This is given. Now, we qualified because the cutoff mark is 47, we got 51. Now, I will show that. Now, kindly see page 34. See page 34. This is 13.5. How a certificate is to be given. Lordship got it 13.5. SC, ST, so and so certificate along with declaration, income asset certificate must be prescribed format available at later job opening under so and so, so and so. Now, if you see the format, kindly see the format. This is at page 39. Kindly see the format.
Yes.
What you got it? This is the format. Annexure 5, as indicated under clause 13.5. Now see at page 41, which is issued by the Office of the Assistant Commissioner for Deputy Commissioner. See at page 41, how it was filled up. Page 41. Now you see, my lord, this belongs to scheduled caste, which is recognized scheduled caste. It should have been belongs to so and so, subcaste Mali. So this has been issued by the Office of the Deputy Commissioner. Now, my admit card I got at page 43. I'll look into my admit card 43, and impugned is at page 47. Kindly see impugned at 47. 47. See remarks, cutoff mark, total marks at page 47.
Hmm.
See total score out. That is your lordship marks in after remarks 1, 2, 3. Before that, total score out of 100 is 51,
Hmm.
and the cutoff mark is 47. So I qualified. Now, remarks kindly be noted. Caste not verified, as name of caste not mentioned in the caste certificate. Now, lordship got it. This has been put to challenge. Now, kindly see the affidavit that has been filed by the oil, that is All India Corporation. Lordship got it. Para 7 kindly be seen. Para 7 and para 8 at page 52.
Yes.
That with regard to the statement made in para 7 of the report, the answering respondent state documents are not scrutinized at the state of submission of the same, and documents are to be verified for only those candidates who become eligible for the next stage after conduct of CBT. So they said, my lord, all the documents are verified after you qualify CBT. Thereafter, the documents are verified. This is what they said. Now, if your lordship looks at page 53, what they are saying, 53 at para 8. See para 8, my lord. That the statement made in para 8 of the writ petition is wholly not correct. It is denied that the petitioner has been disqualified, but no fault of his, and has been alleged. As stated earlier, the form of caste certificate submitted by the petitioner is defective, as the name of the caste is not mentioned, for which the same could not be verified. Also, as submitted by answering respondent, as above, candidature of candidates purely provisional subject to eligibility under verification before or is after his appointment in IOCL. Now, my lord, para 9.
Yes.
Now, this is what they said, that the absolute, we said it is not our fault. It is a fault of the deputy commissioner, where their subcaste Mali has not been mentioned.
Hmm.
So now, this is the whole case. Now, my lord will kindly see, this was filed on 6/3/2025. Now, after that, we file a reply on 27/3/2025. Now, kindly see, an office memorandum has been annexed at page 64. Lordship will kindly look at the office memorandum. And what we said, that it is absolutely not our fault, all this, we have 64. An office memorandum of 28th of March 2024. If Lordship looks into it, reservation for SC, ST, OBC in post.
Whose affidavit?
This is our reply
Right.
to the affidavit, which is, I just read, the Indian Oil Corporation, my lord. The affidavit which I have read, which paragraph 7 and 8. This is our reply.
28th of March.
It went, yes, correct,
Is it
correct.
28th of March?
Yes. And they filed on 6th of March 2025. 6th of March. And we file on 28th. This is 64, office memorandum, reservation of so and so. What you got it? Now please turn to page 101. This is not a false certificate. Even in respect of false certificate, what normally by an office memorandum, provisional appointment in case Lordship got it.
Yes.
Now see where a candidate belonging to scheduled caste, scheduled tribe and other backward class is unable to produce a certificate from any of the prescribed authorities, he may be appointed provisionally on the basis of whatever prima facie proof he or she is able to produce in support of his her claim, subject to his or furnishing the prescribed certificate within a reasonable time, and if there is a genuine difficulty in his or obtaining a certificate, appointing authority should itself verify his her claim through the district magistrate concerned, even if it is a false certificate. I'm showing the worst case here. Here is not a false certificate. Here is only where the subcaste was not mentioned. This is what I am showing before it. Even our Lordship knows the medical admission also, that is given for even you, time is been granted. You get a provisional admission by the time a time is given to a candidature. Now I'll show, this is very important, one additional affidavit. On 2/5/2025, we have filed. After reply was filed, based on this reply, my lord, they made an inquiry. The Indian Oil Corporation has made an inquiry. What is the position? Whether the subcaste really belongs to me, this candidate as a Mali. Now see at page 117. This is by the ADC, which is given to me, a forwarding copy. Inquiry report. See, with reference to the subject, Lordship got it? I am to enclose here a letter submitted by this office, CGM, Guwahati Refinery, regarding caste verification respect of so and so. Is now you turn to page, my lord, 118. Please turn to page 118. The report which was communicated to the Chief General Manager, Indian Oil Corporation on 3/4/2021. Lordship got it? Now kindly see, with reference to the subject cited above, I am to inform you that a caste certificate bearing dated 4/11/2019 issued by this office had not mentioned the caste as Mali. After verification of the caste certificate of C so and so, that is the petitioner, so and his father C Dharmeshwar Malakar, it is found that they belong to Mali caste, which is recognized as scheduled caste under the constitution so and so. It is pertinent to mention here that a writ petition bearing number so and so has been pending before this Honorable High Court, wherein by an order dated 8/1/2025, the Honorable High Court has observed petitioner so and so belong to SC category subcaste Mali. Accordingly, respondent number authorities have been directed not to fill up one post of so and so, which has been reserved of so and so. This is for favor of your kind information and necessary action. So they also verify that whether I belong to the subcaste Mali or not. Where is the wrong thing have done? And latest electronic at page 119, kindly see annexure 12. They have annexed with that also. Report. Kindly see the next page, my lord. These are all electronically, digitally. One next page at 119. See this, my lord, latest certificate, which shows, my lord, this is certified so and so in the state, belongs to Mali caste. Lordship got it? Which is recognized in so and so. This was annexed with the report. So this is the case in hand, my. Now let us see how it is dealt by this type of case. My lord, I'll show one judgment of the Supreme Court. Two 2005, 9 SCC, page 779. Paragraph 7 and 8. Lordship got it, my lord? 2005, 9 SCC, page 779.
Yes. Paragraph?
Paragraph 7 and 8.
Thank you.
See paragraph 7. General rule, well, Lordship, can I read this?
Yes,
This paragraph is important.
Yes.
General rule is that while applying for any course of study or a post, a person must possess the eligibility qualification on the last date fixed for such purpose, either in the admission voucher or in the application form, as the case may be, unless there is an express provision to the contrary. There can be no relaxation in the regard that is a matter of holding the requisite eligibility qualification by the date fixed. This has to be established by producing the necessary certificate, degree, or mark sheet. Similarly, in order to avail of the benefit of reservation or weightage, etc., necessary certificate have to be produced. These are document in nature of proof of holding of a particular qualification or percentage of mark secured or entitlement to benefit of reservation. Depending upon the facts of the case, there can be some relaxation in a matter of submission of proof, and it will not be properly to apply any rigid principle as it pertains in the domain of the procedure. Every infraction of the rule relating to submission of the proof need not necessarily result in rejection of candidature. The principle was explained and applied in so and so. Controversy here related to admission to a postgraduate course in medicine. The relevant rule provided for addition of 10 marks, 10 percentage marks if a candidate possesses of a diploma in the relevant subject or subspecially, and this benefit could be given only if the candidate's success in the diploma course was brought to the knowledge of the selection committee before completion of selection in an authentic or acceptable manner. Prospectus provided that the attested copy of statement of marks and other document should be attached with every application. 3 such candidates, Lordship will kindly mark, were given admission who has not attached this certificate of having passed the diploma along with their application. Your Lordship will kindly mark that. Their admission to postgraduate course was set aside by the High Court on the ground that their application wherein they claim the benefit of diploma were liable to be rejected as the requisite certificate has not been attached. Court speaking to Krishna IRJ reversed the judgment of the High Court and held admission of a candidate has rightly been given as they had in fact passed the diploma before the date fixed. Year 2011, my caste certificate, my lord. Now the ADC that has put that caste certificate as Mali, a scheduled caste. The relevant para of 20 and 24 of the judgment where it highlighted 20, my lord, there is nothing unreasonable or arbitrary in adding 10 marks for holders of a diploma, but to earn this extra 10 marks, diploma must be obtained at least on or before the last date of the application, not later. Proof of having obtained a diploma is different from the factum of having got it. Has the candidate in fact secured a diploma before the final date of application for admission to a degree course? That is the primary question. It is prudent to produce certificate evidence of the diploma along with the application, but that is secondary. Relaxation of the date on the first is illegal, not so on the second. Academic excellence to a diploma for which extra mark is granted cannot be denuded because proof is produced not later, yet before the date of actual selection. Emphasis is on diploma. The proof therefore serves up the factum of possession of diploma, and it is not an independent factor. Mode of proof is geared to the goal of qualification in question. It is subverse of sound interpretation and realistic decoding of the prescription of telescope the two and make both mandatory in point of time. What is now, my lord, kindly mark it. What is essential is the possession of a diploma before the given date. What is ancillary is a safe mode of proof of the qualification. To confuse between a fact and its proof is blurred perspicacity. To make mandatory date of acquiring the additional qualification before the last date for application makes sense, but it is unshakably shown that the qualification has been acquired before the relevant date, as is the case here, to invalidate this merit factor because proof, though indubitable, was adduced a few days later, but before the selection or in any manner not mentioned in the prospectus, but still above board is to make procedure not the handmaid but the mistress and form not a servant to substance but a superior to the essence. It is notorious that the formalities ritualistic approach is unrealistic and unwitting, traumatic, unjust, and so of the purpose of exercise. This way of viewing problem dehumanizes the administrative, judicial, and even legislative process in the wider perspective of law for men and not men for law. Much of hardship and harassment in administration flows from overemphasis on the external rather than the essential. We think that government and the selection committee rightly treated as directory not mandatory, the mode of providing the holding of diplomas, and as a mandatory, the actual possession of diploma. In actual life, we know how so and so dilatory it is to get copies of decree and deeds, not to speak of other authentic document like mark sheet from university. Why even bail orders from courts and government orders in public office? 9 is very important, my lord. The appellant undoubtedly belong to reserve MI category. She comes from a very humble background. Her father was only a Nayak in the armed forces. He may not have noticed the mistake, which has been now Lordship will kindly mark this. He may not have noticed the mistake which had been committed by Jila Sainik Board while issuing the first certificate dated 29/6/2023. But it does not mean the appellant should be denied her due when she produced a correct certificate at the stage of second counseling. Those who secured rank lower than the appellant have already been admitted. The view taken by authorities in denying admission appellant is only unjust and illegal. The appellant had qualified, but the said academy is already over. But for so and so, with the respondent who adopted a highly technical, rigid attitude, not with the appellant, we are therefore the opinion appellant should be given admission any of the state medical in the current academic so and so. So here also, the deputy commissioner himself, my lord, will kindly see where is the statement made. Additional affidavit, he made a statement here. We said. Yes, in 118 also he made a statement, my lord, 118, which was forwarded. So your lordship will kindly see at page 118. This is what the AGC has said. With reference to, I am to inform the caste certificate issued by this office had not mentioned the caste as Mali. Here also you just see, my lord, the para 9.
Para 9 of?
Para 9 of the judgment. Para 9 of the judgment. So this is my case, my lord. Even then I qualified, it is by 51 and the qualifying marks is 47. Why it should be denied? That is why at the very first stage when the matter was moved before this court, prima facie court was satisfied and one post has been kept vacant and said it will further we have to deliberate this matter. So this is my humble submission before this court.
Wait, please, Your Lordship. My lord, there are two matters, item number 8 and item number 9. I am appearing in item number 9, my lord. And in this, and he is my learned friend, 8. Since the issue is same, my lord, I'll address Your Lordship. Now, if Your Lordship should kindly come to page 41 here. The factual aspects are clear now.
You are now referring to item 9.
No, Lordship will refer to item 8 only, page 41. Same issue, therefore. This is annexure 5, my lord. This is the form of caste certificate.
Yes.
Kindly see, my lord. This is to certify so and so son, daughter of so and so in so and so district of the state territory belongs to dash caste, which is recognized as scheduled caste or scheduled tribe. Now, in this case, to which caste my learned friend's client belongs, it was not indicated. So this is the format. Now, it is not an issue whether he belongs to ST or not. Question is whether he was diligent enough to, my lord, indicate his correct status. And if it is not done, and if it is rejected, then whether it can be said to be an arbitrary exercise of power. My lord, this issue is squarely covered by recent Supreme Court judgment, my lord, very recent Supreme Court judgment. 2025 SCC Online 1125. The approach has changed, my lord. The one which my learned friend read, that is Dolly Chanda's case, that approach has changed. Now please come to the facts, my lord. Respondent number 3, page number 1125. Yes, please come to the very first page, my lord. Respondent number 3, Uttar Pradesh Recruitment and Promotion Board issued a notification on 24th of February 21 for direct recruitment on the post of sub-inspector civil police and platoon commander PSC, and fire officer for the year 2021. The appellant Mohit Kumar on 20th April 21 applied for the post of sub-inspector, civil police as well as platoon commander, and was thereafter called for examination, which was held on 17th of May 22. Pursuant to the examination conducted by so-and-so, Mohit scored 313.81 marks. A list of non-selected candidates came to be published, which featured Mohit's registration number at serial number so-and-so. Aggrieved thereby, Mohit made a representation to so-and-so on 21st of July. Receiving no response, Mohit moved the writ court before the High Court, praying that his representation be considered. High Court on 4th August directed Superintendent of Police to consider representation and pass a reasoned order thereon within 4 weeks. Respondent number 4, by its speaking order dated 15th of September 22, rejected Mohit's representation on the ground that he did not submit OBC certificate in the format prescribed at the time of initial recruitment release, and thus he was considered in the general category. Now, because the certificate in support of his candidature was not in form, therefore he was treated to be general. In other words, his OBC certificate was not accepted. Now, the reason was it was not in form. Milord will kindly come to page number, paragraph number 12 at para 12 of this judgment, Milord. Issue. I'm sorry, Milord, it is not
SCC online.
Yeah.
Page number.
in SCC.
yes.
Yes, 12. The issue that arises for consideration is whether UPPRPB was bound to accept the OBC certificate submitted by Mohit and Kiran, which admittedly were not in the format prescribed in the recruitment notification. So this was the issue, Milord. Now please come to paragraph 14.
Yes.
What follows from the above decision is that irrespective of whether an aspirant for public employment belongs to a particular community like SC, ST, OBC, the status claimed by him for being accorded the benefit of reservation is per se not decisive. Such status has to be certified by competent authority upon following due process and identification that the aspirant is what he claims to be. In Srinivas Prasad versus Supra, the requirement of production of a certificate from competent authority was held to be mandatory in view of the statutory mandate. Although there is no such statutory mandate in the facts of the present case, the requirement in question is no less mandatory and must be scrupulously followed. Once a process of recruitment is set in motion, all aspirants are entitled in law to equal treatment. There cannot be different yardstick for different sets of aspirants. Non-compliance with the terms of the advertisement notification is bound to trigger adverse consequence of rejection of the aspirant's claim status by selecting body appointing authority should he choose not to adhere to the same. Having regard thereto, the selecting appointing authority would be justified in not entertaining the application of an aspirant as a member of the community for whom the reservations are permissible. Now, my lord, please come to paragraph 17. Somewhere in the middle, sentence starting with, however, since it has been assiduously argued by Kaushik that Mohit after all belongs to OBC and Kumar Gaurav appearing for Kiran has supported him, we consider it proper to deal with such an argument too. The argument was advanced. Where is the dispute that he doesn't belong to OBC? So that was also dealt with, my lord. Now please come to para 19, my lord. It is no longer res integra that terms of an advertisement issued in connection with a selection process are normally not open to challenge unless the challenge is founded on the ground of breach of Article 16 or for that matter Article 14. Once an advertisement is issued inviting application for public employment, it is the responsibility, nay duty of an aspirant to read and note the terms and understand what is its requirements are. If any aspirant finds any of the terms ambiguous, or there is scope for any inquiry inbuilt in the advertisement, or is provided by any rule regulation, an effort ought to be made first to obtain clarity for understanding the requirements accurately. If no such scope is available, nothing prevents the aspirant from seeking clarity by making a representation. Should such a clarity be not provided, the aspirant may participate in the selection process without prejudice to his right and may question the term even after he is not selected. However, if the aspirant does not make any such effort and takes a calculated chance of selection based on his own understanding of the disputed term in the advertisement, and later he emerges unsuccessful, ordinarily it will not be open to him to challenge the selection on the ground the disputed term is capable of being understood differently. In such cases, court should be loath to entertain such plea of ambiguity while preferring to accept the recruiting authority's understanding of the said term. This is for the simple reason.
What was the ambiguity here in this matter?
Here, my lord,
In this matter that you're referring?
in this matter, my lord, that OBC certificate was not informed, as is here.
No, not in the case before the apex court.
Yes, issue before the apex court was, please come to my lord, the third page. The Roman 2, the advertisement stated that 2437 posts were reserved for OBC candidates and laid down third page, my lord. There is a clause 5.44.
Yes.
If the candidate belongs to other backward class category, do not submit the certificate in prescribed format within the prescribed period, or if they submit the certificate of other backward category valid for service of Government of India, they will be treated as a candidate of unreserved category. If they submit a certificate which is not in form, then it will not be treated as an OBC, it will be treated as a general category. In other words, the OBC status was rejected in this case, as has been.
And what was the defect of the petitioner?
It was not in form.
To what extent?
If your lordship should kindly come to para 4, my lord.
Well, we'll have to come back after.
Yeah, oh yes, I'm so sorry.
No, you don't have to be.
That's only, my lord, 2 o'clock one election matter is there, so I'll just give a reply after that, my.
No problem.
I am sorry I had to break it, but there's some meetings actually.
No, it's okay, my lord. No, already 1 o'clock. Even I should have pointed out. Para 12, the issue part which I have already placed, please come to para 13. We may initiate our discussion by first referring to this court decision in Register General Calcutta High Court versus Srinivas Prasad Shah. This is my lord 2023 12 SCC 364. The question that was raised is whether West Bengal Public Service Commission was justified in considering the first respondent as a general candidate for recruitment in connection with the judicial service examination instead of his claim of being a member of the scheduled tribe community. The advertisement stipulated that in order to obtain the benefit of reservation, the requisite certificate had to be issued by the competent authority as specified in the stated enactment and the SCST Welfare Department order dated 6th of April 95. Instead of producing a certificate issued by the competent authority, the first respondent produced a certificate issued by Director of Backward Class Welfare Department, certifying him as a member of the scheduled tribe community. Hence, such certificate was ignored and he was considered as a general. The first respondent was fortunate enough to succeed in 2 trials before the High Court at Calcutta, which directed the Public Service Commission to consider him as an ST candidate. Fortune deserted him before this court. It was Judge Helms. We find no error in the decision taken by the Commission in not entertaining the respondent's application as an ST candidate
since no certificate was produced from the competent authority, as provided under the welfare law. The information to the candidate specifically stated that candidate claiming to be SC/ST must have a certificate from a competent authority specified in West Bengal Act. No such certificate was produced from the competent authority by respondent. Consequently, in the absence of requisite certificate, Commission was justified in treating him as a general category candidate. The first time the respondent produced the certificate from the competent authority was only when he appeared in the examination held on 27/2010, and by that time he had obtained a certificate from competent authority on 22/9/2009. Admittedly, at the time when the 2007 examination was held, no such certificate was produced from the competent authority along with the application. Consequently, respondent was treated as a general category candidate, and hence he could not be appointed as a judicial officer in examination held in the year 2007. We are of the considered opinion that in view of the specific legislation passed by the West Bengal, etc., and specific stipulation in the notification issued to the candidate guideline 10 of para 13 of Madhuri Patil is inapplicable, particularly to the facts of this case. The Act does not recognize the director of backward class welfare West Bengal as a competent authority to issue the certificate. Therefore, Commission was justified in not placing reliance on certificate issued by the director. Here in this case, my lord, the certificate was not by the competent authority, it was by the director. Nonetheless, it is a pre-existing document. It's not that there's a fact he was a scheduled crime, but the benefit was denied. Now, please come to our case. Now, what are the stipulations in the under this advertisement notice? Lord, will first come to page number 32. Page 32. The heading is how to apply online application. Please come to serial 4. How to apply? Then serial number 4.
Yes.
Candidates should take utmost care to furnish correct details while filing in online application. Any mistake committed by a candidate shall be his or her responsibility. Once application is submitted, no change, edit will be allowed thereof. Let's please come to the next page, page 33. Please refer detailed instruction sheet while filling up the online registration form. Sign up. Please come to step B. The candidate should now fill all the desired information in online form about himself, herself correctly and register. The details to be filed with registration will input, etc. Then below will kindly come to serial number 9 towards bottom of the page. The candidate must ascertain correctness of each information detailed before filing in the online application and its final submission. Candidates shall be wholly and exclusively responsible for the information details so filled provided in his or her online application form. Then below will kindly come to page 34. 13 Roman 5. This is very important. SC, ST, disability certificate, OBC, NCL certificate, along with declaration, EWF income and asset certificate, must be in the prescribed form.
Which is the format enclosed to the form.
Then we will kindly come to page 35, serial number 19. Before submission of the final online application, candidates must check that they have filled correct details in each filled up form. After submission of the final online application form, no change, correction, modification will be allowed under any circumstance. request received in this regard in any form like post, fax, email by hand, etc., shall not be entertained by Indian Oil and will be summoned visited. Then please come to the last clause of 27. Only queries related to online application software shall be replied to helpdesk app and helpline number. Not what the underlying legal principle which is decided to live and also. You have to be very vigilant. You have to take enough care in. Well, end of the day, nowadays, because of this unemployment problem, then whenever any poster advertised, there are thousands of thousands. It's not possible, my lord, to redo it every time. Therefore, utmost care should be taken. End of the day, if you're not diligent enough, then you'll miss the bus. The issue is, my lord, this approach has received the approval of the Supreme. Therefore, my lord, I think the issue rests. There is no question of any issue. The approach which was adopted in this case by Arbitration is reliable. That was the case of 2005. Now we are in 2025. The legal thinking has to also change without this passage of that. So now the present understanding is without, like in tender matter, you'll have to be extra careful. Because nowadays is the online, things are being done. Therefore, once you commit a mistake, it is irretrievable. So therefore, my humble submission, it cannot be said that the authorities associate arbitrate. Our stand is backed by the two authorities of the Supreme Court. In fact, that 23-12-354 is another judgment which again came from Calcutta High Court. Eventually, the Calcutta High Court single bench and division bench and also Supreme Court says on this employee we cannot. So even if it is a pre-existing document, it will not be entered. And you have the mathematical perhaps the reputation devoid of any merit. First, you will also be looking to it. The judgment which is cited on November 10 is of two judges and the senior. And in this case, of the last judgment which is cited 2025, they have two judges and it will be two people. 2005 is a figure, and this judgment of Chanda has been deferred in this case. Now, what is the effect of this case? Kindly look into it. Paragraph 4. Paragraph 4.
Oh,
of
which-
the- of the judgment. Paragraph 4. Response number 4, by speaking order dated 15th of September, rejected Mohit reputation on the ground that he did not commit policy certificate in the format prescribed at the time of initial recruitment dating, and thus he was considered in the general category instead of OPC category. Control mark for a general category were 316.1 mark, whereas for the OPC category it was 305.542. The order also stated in as per Mohit's own case, at the time of application, he has mentioned the certificate issued by central government instead of the state government. Well, this is what the case about. It is has to be submitted so far that instead of state government, he has submitted certificate of the central government. This is by the applicant. Here, if you are also trying to see the format 13B of the format in pursuance to the advertisement, it is by a competent authority who will issue. Not by the applicant. It is a competent authority who will have to issue. Now, who is a competent authority? Competent authority, Deputy Commissioner. Where they regretted, it is our fault. They regretted, it is our fault. It is a fact that 2011 certificate was issued by the Deputy Commissioner Office, where the subtask is Malik. 4/11/2019, it is a competent authority who will issue, not me. Here is the case where the applicant, he has filed instead of that. So kindly see the format, kindly see that the 13.5, kindly see 13.5. at page 34, which my learned friend has read, of the writ petition. See,
Yes.
13.5. SC so and so must be prescribed format so and so and issued by the competent authority. Now, kindly see who is the competent authority here, who has issued, who has filled up at page 41 and 42. It is not the candidate, but I could understand very well. It is, sir, I cannot improvise the certificate. This is by them who has issued the certificate, who has filled up, and when they have mentioned the schedule class. I just see at page 41.
Yes.
So there is a difference with the facts of the case which my learned friend has cited. Number one, this is the two judges, there is three judges. Rolly Chandra has been also been mentioned while deciding this case in 2025.
Where is it referred?
Right, yes. I see. Hello, kindly see 10. Error 10 of the 2024 value.
Serial 5,
Submit. File.
Roman 5.
Yes. The decision of so and so was cited, either with every infection of your did not cancel result in the rejection of the candidate. So this was there. Kindly see the facts which really furnish its heart with Dolly Chandra. Again, I'm trying troubling your lordship with paragraph 9 of Dolly Chandra. Please look into it, my paragraph 9. How it is similar with our case. Kindly say paragraph 9. That will please the issue 9. The applicant undoubtedly belong to reserve MI category. She comes from very humble background. Our father was only a Nayak in the armed forces. He may not have noticed, kindly see, he may not have noticed the mistake which has been committed by Jila Signing Board, which while issuing the first certificate dated 29/6/2003, but it does not mean that the applicant should be denied her due when she produces a correct certificate at this stage of second counseling. Now here, the Oil India, that's a Indian oil corporation, wants to make an inquiry. When this was they made an inquiry. They have requested the ADC that we want to know whether the caste certificate which is issued is really belongs to Mali. Now they come up and they inform us along with the Indian Oil Corporation. Yes, it is a Mali certificate, but mistakenly it has not been mentioned. So now kindly see thereafter. Those who declared rank lower than the applicant is our case. Have already been admitted. You question by the order denying admit the applicant is only unjust and illegal. Now the cutoff mark was 47. So my mark was 51. So very well I was above the other candidate. So in that view of the matter, I think the judgment which was placed before the Honorable Court, that is not available in the facts and circumstances. That's my reply. I'll let you know.
Just one question.
And I say that Dolly Chanda was considered, then it's a worst case scenario. Dolly Chanda was considered that for minor infraction, I mean, this harsh decisions not be taken. That was not considered. All that I am saying is not, so one thing to take a sympathetic view in the matter is another thing to apply the legal yardsticks laid down by the.
So according to the respondents, he was rejected
Yes.
because the format was not followed.
Yes. Format was.
No, which is your format? 39.
Yes, page 39.
39.
Yeah.
And what is the form submitted by the petitioner?
Yes, what?
No, the one submitted by the petitioner, 41.
Page 41.
41. Now, where is the shortfall of the petitioner?
Yeah. Because schedule card there is another space. You should have said belongs.
Mali is a subcaste. It's not a scheduled caste.
Going by the form, what he should have written was
belongs to Mali caste, which is a recognized schedule. So there is
Mali
no
is not a caste. Mali is not a caste. See, that explanation will apply to a tribe. If you see that caste/tribe,
Yes.
so and so, no. See, scheduled caste are a group of recognized castes and subcastes. Now, here is a case where this person belong to a subcaste of a scheduled caste.
If a lot looks at,
Uh,
if a lot looks at 1950 scheduled caste order,
hmm.
as far as Assam is concerned, there are different groups, castes. For example, Koibordo is also a scheduled caste. Ali is also a scheduled caste. So what is the incumbent as per the applicant application form is, he must mention his caste first. Otherwise, that is a scheduled caste, it is already indicated.
Is it a caste or a subcaste?
So, caste. I have 3 page 15, I have to place the issue. 15 of my requisition.
1-5.
One, see the requisition. I not see 15. Please see 15 plus. If a lot the deputy commissioner is different. A lot, if a lordship will kindly come to page 119, there subcast is Mali, kindly see. There's a subcast. Here, page 15.
Yes.
Lordship, what is page 15?
Yes, yes.
See, belong to civil caste, subcast is Mali.
What does the order say?
Which one?
The scheduled caste presidential.
Yeah.
Do you have a copy of that?
I think, my lord, the correct certificate is at page 119. Page 119.
Mali caste.
Yes. This is to certify that Konkonprati Malakar, son of so-and-so, 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 in the state of Assam belongs to Mali caste. This is a recognized scheduled caste under this procedure. So this application should have been in this one. It was given in this one. And our description in the advertisement says you must take adequate care, be diligent and fill up the form. If you have got any query, please call up this number.
But this queries are only relating to the software.
Yes. Case, there are enough portions are given. But I'm for a moment, I
And-
don't say it's like ours.
And
This is the yardstick.
in the facts before the Supreme Court,
Yeah.
the person's criteria, what was that category, was reject or not considered, but he was considered in the general category.
Mark.
No, that's all right. But here is a case where he was
Direct judgment.
on which date? On which date? Huh?
Yes, yes. No, well, here also we'll consider as general. No, you just, why not, whatever maybe it go against me or favor. My case is that this is what the applicant has not made a mistake, it's a authority in filling up the form has made a mistake. That's the case which I am relying. Dolly Chandra case. And in the present case, 2025, it is the applicant.
See, page number 15 is a certificate produced by the Deputy Commissioner.
Yeah.
And 119, or what page was it? 119 is also by the Deputy Commissioner. See the description of the caste, different.
Yes.
You are relying on 15, which is issued by the Deputy Commissioner, Kamrup.
1 month of given by the deputy commissioner along with 118. 118 it was given, it is not available, they have given.
Huh?
I was the deputy commissioner
While at 118, is clarification has been made to the chief judge manager.
No, no, all right. We are
Yes.
saying 115 is issued by whom? Deputy Commissioner.
Yeah.
118 is also issued by the Deputy Commissioner. So, no, not on that. The question is whether Mali is a caste or a subcaste.
That's fine.
All right.
Your in Assam, we got ask for Win Mali or Mali, Little Gonia or Gonia, Upi or Dhobi, Tukla or Dhuli, Hira, Al or Malo, Oiboto or Jani. All are scheduled castes. So all that is sort to be prescribed with you must indicate your caste. Then you become a then you as a scheduled caste. Now that is not there. Because in whatever form, the ratio of the Supreme Court is very simple. If it is not in the form, you are not liable. Let me see this. This is a gazette. No, we are not disputing that Mali is a scheduled caste. We are not disputing that. What we are saying here, subject to the provision of this ordinance caste, race or tribe, or parts of, or group within, common caste or tribe, within caste or tribes.
Where is that?
Part one.
Ah, okay. You just have one copy. You read it and you give it to us. You read it and if there's one copy, you read it and give it to us. Yes.
Of parts of the group within caste or tribes, specified in part one to financial, in relation to financial, this is part. Is linked to the scheduled class, so far Bihar member thereof, resident in the locally specified in relation to in the parts of the city. So they are deemed to be a scheduled class, but they are different. So kind of in Assam, two of the state, they are scheduled class, but they belong to this caste, privacy. 1, 2. Two kindly see. Schedule part 1 Assam, 2 of the state, so and so Mali. They belong to scheduled caste, or there is a class which called a subcaste. So whatever may be in my caste, is a scheduled caste. In the format also, they have some mention, kindly see, belongs to scheduled caste, which is recognized scheduled caste, which is described under service.
Yes.
That's all. What case, you must mention the specific caste, by virtue of which you are a scheduled caste. And that is this.
You will have to satisfy the court with at least one authority to say that your judgment holds the field, notwithstanding the subsequent judgment. You have relied on Dolly Chanda. So your claim is that this is a 3-judge bench judgment, so this has to prevail.
Just like answering prevail,
Ah.
it has to prevail with the facts of the case. They are prevailing, which doesn't tell you the facts.
No, I'm not on that. I'm on that. There are authorities which clearly lay down that which judgment would be binding. Jammu and Kashmir. You will show us and tell us, we'll have to deal with it now that we are confronted with. But prima facie, it appears that in the subsequent judgment, The issue was the benefit he wanted to obtain as an OBC. He was shortlisted as a general candidate. But
Not taking part, taking some OBC, it is not.
he has to be selected, correct?
Yeah. Imagine, why? As a general, you are giving more. Now, because I applied in SC category, how can you treat me as a general? I applied in SC category. There are specific cases here, SC category.
Right, heard counsel for parties for orders. We are not available for the next 2 weeks, so it has to be we'll keep it on 11th. 11th for orders. Mr. Sutia appears for respondent 3. You did not submit anything?
Submission is over. Suppose for DC forward 3 officer ABC, you customize member wearing a white shirt. One is wearing a blue shirt. Whether the blue shirt is the death officer, yes or not. That is the thing.
No, but what if one wears a off-white shirt and the other wears another white shirt? Do you say that the person wearing off-white is not wearing white? But the whole problem has been caused by you. Why are you not careful about issuing certificates?
I have seen the 41.
All right. On what did he say? 11th. Heard counsel for parties matters to be listed for orders on 11th. Item 9, your Mr. Same arguments. OBC, ST. In your petition also, there is a defect in the form. Where is that form? Where is that certificate? No.
Mr. And they have here, I pay.
Here it is STP, but same defect. All right.
Say everything is same. Only thing is there it is SC, here it is SC.
Item 10.
এইটো মাৰ্ক কৰি থব হা 11 তাৰিখ ক'লো নহয় চৰি কোন তাৰিখে দিলো 11 চ' এইটো মোক আপুনি 9 তাৰিখে হেণ্ড অভাৰ কৰি দিব ফাইলটো What is this? I can't hear you. Sorry. No, they're considering your matter. Yes. Heard counsel for parties, Mr. Who has submitted this? The counsel appearing for the revenue department submits that the case of the petitioner is under active consideration for release of you're seeking release of pension, area salary, and including current salary, and for which several documents have been sought for from the Department of Revenue and Disaster Management. In this connection, the inter-department communication dated 21/08/2025 is placed before the court by the Counsel for the Revenue. Stop. The Mr. Dotto, Standing Counsel Revenue, prays for 3 weeks. 3 weeks. Let it be 3 weeks, by which date the council will update the court list again on 15th September. Mr. Choliha for the Revenue Department, Mr. Sutia for 1 and 5. Yes.
Time being item 5.
I think 500 after other.
Of Foreigners Tribunal.
Not Kane Miller. Went to any.
But somebody will have to take the exercise here. Who is going to determine whether they're doing the same work or not? Is there any dispute that they're not performing the same nature of work?
We are looking, send the letter, but the things that could be a bit. That problem. Other looks at the order of the. Mechanism also. This tribunal also is elaborately given in their services.
What is there? Hmm.
The 35 pages. And this is
Let us see if we can find it here. This is a full bench order. You're referring to the full bench. Yes, paragraph.
elaborately given the mechanism.
133. Hmm.
Sense of the quality of justice to the suffered if evident and competent persons are not appointed as member of the foreigners tribunal it may also be against the national interest of the importation of the foreigners from India. As noted above, the state government is appointing retired judges, judicial officer as member of the foreigners tribunal without undertaking any selection process, mainly because of non-availability of the adequate members of the retired judicial officers. Adequate members of the foreigners tribunal are required to be constituted to deal with
This is not the issue here. The issue is that they are appointed, there's no quarrel that they are appointed on what contract. Contract. So they want equal pay parity. So who will pay them? Who is paying their salary? Government of India. So where is that proposal? You had earlier rejected some. But what do you say in terms of the judgment of Jagjit Singh? Hmm. They are employed where? They are employed in which tribunals? What about the findings of the judgment here? It's an apex court judgment, it's binding. Whatever it may be, you read para 56 onwards of the judgment. Two 1 4. Petitioners are? Huh. This is 1988. Where is the department's? There are some judgments referred here. What judgments are referred here? Any indication? This is issued in 2019. It appears to have been issued immediately after Jagjit Singh. It talks about judgments, Honorable Supreme Court's judgments. Which judgments?
Grade 4 employees, they were given 6 pay. And some teachers were also 6 pay. They said that no, they have to give equal pay like others. 6 pay will not do, and Jagdish Singh has been referred to. The Jagdish Singh, no, well, again, Mohor Ali state has been given, and Mohor Ali has relied on Jagdish. And there are 16 some.
Hmm.
After Jagdish Singh, all the judgment, and if people will totally want to say that it also relied on Jagdish Singh saying that even the Macron employees might not have continuing and doing some work like NBA out there, he paid that salary. No retirement benefit, nothing matter, but salary has to be paid equally. In case of judgment matter, relied.
Yes. Where is that rejection order of the central government? 203. Yes.
Another key matter, the reason has been taken away. Why they are not taking up the. Government also has proposed creation of contract that is. They have been agreed on contract that. That's temporary form. It is called insurance. The services are purely temporary in nature. Our government has been. It was easy to grant regular fees. However, the advertisement by which we are recruited. They are engaged, number of staff like NGA, UTA, stenographer, they are all contractual. In the same advertisement, they are given statement. So this reason does not hold good enough. The same advertisement, contractual value, they are given state, we are not. Here, exactly, madam, we are not asking for scale of.
You are in the additional 64 temporary additional. You are employed there. But is there any distinction between the works which they are doing, assuming they are under additional? What is 78? From where do you find this is in additional? What is the nature of your work as data entry? Where are the appointment letters? 78 is only for data entry. 90. This is for copyist.
We are not taking this down, therefore this is not a case that whether we are starting at data entry operator or not, the question does not arise. If we were recorded on casual basis or master road, and we claim that we are starting in some specific code, then the question arises, we have to prove that we are starting in the code. And here, specific code value. We are not taking objections to that we are not starting in data entry.
Where is that after 94, which other page? Office 101. Yes.
They are claiming salary equivalent to the state. As their own notification, they are saying that if they are doing it, that are denied above manner. Then there should be given that available care divided by 30 so that their daily wage can be calculated.
Where is that notification?
That my manner from 1 to 1 number. From the previous manner. Nature of work interested to the casual workers are regular and paid. The casual workers may be paid at the rate.
You want this?
Yes.
You
Paid. We want that our revenue should be paid.
you want it at the rate at the calculation given in 217.
Yes. They are not even asking for the same money. Our remuneration is only 10,000, 9,000 we are running our families with that. No revision minus.
Who has filed? Who has brought it on record? Okay. What do you say with regard to this? And what is the scale paid to the others who are,
Big 103.
no, you were referring to certain, where is the advertisement? So you are saying that up to number 5, they are getting the scale of pay. From number 6, and is there any renewal orders passed?
Condition. Yes. Okay. 2026. Think they didn't continue matter. The problem is not that, so how they can say this inquiry and all. This authority might be given to others. But, as to during the establishment order, that is, page 1 matter. Yes, for additional standard, pursuant to the Supreme Court order matter. Supreme Court procedure.
But the advertisement itself reflected that your service is on a fixed pay. Then on what basis are you now asking that you have accepted this advertisement?
What option you have, madam? Never get it number. But the law is that, madam, the same word were getting done to us, saying a median salary, madam, cannot be thought of as a student, madam. 10,000, 9,000, madam. That is what, the thing saying, madam. We are not entitled for any regulation benefit, we are not entitled for any pensionary benefit, nothing, madam. But the thing what people are doing, that salary has to be given, that amount has to be given. And that is the judgment on whether that recent judgment, I have to give whether other day, if of other, then the part of same judicial is going to be taken. They are not that, 2017, 18 Act provided that they will be a seat pay. The court said that no, it should be done. It is the same law. But government of India is giving paid pay that paying pay to the casual workmen who were not inducted in statutory selection process or in qualifying. They are also given by their own service order. And we are all qualified and we are selected by High Court in a selection process. We can everything.
Okay, heard. Yes, anything more? Anyone for the state to anything to submit? Heard. Mr. B. Chakraborty, learned counsel for the petitioner. MS A. Gayan, appear learned CGC for the state. Mr. J.K. Goswami, appearing for the state government. Stop. The writ petitioners before this court were employed as data entry operators, copyists, office peon, and chowkidar in the various foreigners tribunals established for references with regard to the nationality of suspected foreigners or doubtful citizens. Stop. The petitioners were appointed pursuant to an advertisement issued by the Guwahati High Court by the advertisement number so and so dated 6th of August 2015, Annexure 2. Stop. By the said advertisement, after in view of the establishment of the foreigners tribunals of Assam under the jurisdiction of the Guwahati High Court, the posts were advertised on contractual basis for a period of 2 years. Stop. Several posts, including the posts of LDA assistant, bench assistant, typist, stenographers, etc., were advertised, indicating the pay scale and the grade pay. Stop. However, for the posts of data entry operator, copyist, office peon, and chowkidar, these posts were advertised on a fixed pay basis. Stop. The petitioners applied for and were duly selected in these posts of data entry operators, copyists, office peon, and chowkidars. Stop. Pursuant to their appointment, the petitioners were posted across the state of Assam in various tribunals, foreigners tribunals, and have been rendering their services ever since. Stop. The services of the petitioners, although were initially for a period of 2 years, stood extended subsequently by orders passed by the a competent authority in the government. Stop. The grievance raised before this court by the petitioners is that pursuant to grievance raised by the petitioners are twofold. First, it is submitted that although the appointment was initially for a period of 2 years on contract basis, however, the petitioners' services were rendered have been continued or extended from time to time by orders passed by the competent authority. Stop. The second limb of the argument is that the petitioners are performing the same works as are being done across the state in other government offices as well as in courts. However, their salary has not been brought to the par to the said posts. Stop. Consequently, they have been working on a fixed pay basis for all these years. Stop. Learned counsel for the petitioner has extensively relied on the judgment rendered by the apex court in Jagjit Singh, reported in so and so. Stop. Referring to the said judgment, he submits that the judgment of the apex court lays down that for equal pay, for equal work, there must be equal pay, irrespective of the nomenclature or the status of the employees concerned. Stop. It is submitted that the respondent authorities are duty bound in law to grant equal pay to the petitioners who are rendering services in their posts. In the same range, in the same pay scale as have been granted to other posts across the state. Stop. It is submitted that a proposal for, where is that proposal of the state government? State government proposal? Huh? The proposal was mooted by the government of Assam political B department for revision of the current remuneration structure from fixed pay to, within quotes, to scale pay in respect of these posts, namely posts of data entry operator, copyists, office peon, chowkidar, etc. Stop. This communication was dated 1st of August 2023, was addressed to the Ministry of Home Affairs, Government of India. Stop. The said communication, however, the said proposal, however, stood rejected by communication dated 28th of August 2023, issued by the Ministry of Home Affairs. Stop. By the said communication, it was, the state was informed that since the government of Assam had proposed creation of supporting staff on contract basis, and they have been engaged on contract basis against temporary posts created for additional temporary 64 FTs. Their services are purely temporary in nature and not governed by the rules and regulations applicable to the regular government servants, and therefore it is not feasible to grant regular pay scale to these temporary supporting staff engaged on contractual basis. Para. Learned counsel for the petitioner has also referred to an office memorandum issued by the Government of India, dated being OM number so and so, page 214, dated 7th of June 1988, regarding the review of policy of casual workers and persons on daily wages. Stop. This OM was subsequently revised, and subsequent OM dated 4th of September 2019, page 217, was issued, whereby the Government of India decided that where the nature of work entrusted to casual workers and regular employees is the same, the casual workers may be paid at the rate of 1/30th of the pay of the minimum at the relevant pay scale plus DNS allowance for the work for 8 hours a day. Stop. Para. MS A. Gayon, learned CGC, representing the state, disputes the contentions raised by the counsel for the petitioner. It is submitted on behalf of the union that the entry into the service was pursuant to an advertisement issued by the High Court dated 6th of August 2015, and it is clearly evident in this from the said advertisement that these posts, all the posts were on contractual basis, and the posts of data entry operator, copyist, office peon, and chokidar were on fixed pay basis. Stop. It is submitted that the petitioners, having accepted their terms of appointment, now cannot claim parity of pay with regard to other employees, rather regular government employees. Stop. It is submitted that the office memorandums referred to by the counsel for the petitioners are not applicable to contractual employees, as a mere perusal of the office memorandum reflects that it is meant for casual workers only. Stop. The petitioners, it is submitted that although the petitioners' appointments were extended from time to time by appropriate orders, it is equally necessary to note that while rejecting the prayer for pay revision by the Government of India, it was clearly indicated that the Government of Assam had earlier directed, the Ministry of Home Affairs had earlier issued directions or instructions to the Government of Assam to manage supporting staff through outsourcing services on contractual basis. ID letter number so-and-so dated 6/6/2013, page 203. 6/6/2013 on a fixed pay. Stop. However, the Government of Assam engaged these supporting staff on contract basis through the advertisement. Stop. Therefore, the claim of the petitioner for parity of pay or grant of appropriate pay scale is not applicable, as the terms of their appointments are clearly reflected in the advertisement dated so-and-so issued by the government, issued by the High Court. In response to the referring to the judgment cited by the petitioner, counsel for the petition respondent submits that in view of the nature of engagement of the writ petitioners, the findings of the apex court in the judgment of Jagjit Singh, etc., will not be applicable, as the very source of appointment of the petitioner, basis of appointment of the petitioner was the advertisement dated 6th of August 2015, which clearly indicated that the appointments were on contract basis and on fixed pay. Stop. Counsel for the parties have been heard, pleadings available on record have been carefully perused. The petitioners are appointed as in various capacities as data entry operators, copyists, office peon, and chokidars, pursuant to the advertisement dated 6th of August 2015, for rendering their services in various foreigners tribunal across the state of Assam. Stop. The establishment of these foreigners tribunals are pursuant to the directions of the apex court, read with such decisions taken by the government, both the center as well as the state at the appropriate level. Stop. The purpose of the Foreigners Tribunal is to render opinions on cases where the question of citizenship or nationality of any citizen, of any person, it comes under a cloud on the basis of such investigations carried on by the state agencies. Stop. Time and again, the functioning of these Foreigners Tribunal have been closely monitored by the apex court as well as by this court. Stop. What is this bench which is monitoring? In fact, presently, the Guwahati High Court has a monitoring bench for monitoring the functioning and efficiency of the foreigners tribunals established across the state. Stop. This issue was earlier raised before the said monitoring bench. However, by order dated so and so, the monitoring bench directed that these issues being personal to each of the individual employees, the same was not required to be monitored or supervised by the monitoring bench, and liberty was granted to these petitioners, to these persons or employees to approach appropriate forum individually. What was that order? 31/8/2023. 23. It is pursuant to this order passed that this writ petition has been filed. Stop. It is not the case, it is not disputed by the respondent state as well as by the union that the service rendered by these petitioners are no longer necessary or are likely to be done away with in view of any policy undertaken by the state or the union towards administration and supervision of the administration and functioning of the foreigners tribunal across the state. Stop. There have been several judgments of this court as well as the apex court, which has time and again delved into the functioning and the peculiarity of the nature of the opinions rendered by the foreigners tribunal on the references made to it by the state agencies. Stop. It has been emphasized that these references are required to be answered either in affirmative or negative, but these references require expeditious disposal as it questions, as it puts the status of a nationality of an individual under a cloud. Stop. An opinion rendered against an individual to the effect that that individual is not an Indian national and obligor who had entered into the state of Assam on or after 25/3/1971 has serious consequences which will befall on such an individual, stop. With regard to the such an individual in respect of the question or the status of his nationality as an Indian citizen. Stop. Such opinions which are rendered by the Foreigners Tribunal in order to be rendered without are required to be rendered expeditiously, it is necessary that the tribunals function at its optimum, and for which purpose the services of supporting staff like those of the petitioners are considered indispensable. So, it is not disputed by the respondents that these services of the petitioners are still required in those in the FTs functioning across the state. Stop. No mechanism as on date, no alternative mechanism as on date has been brought out by the state or by the union to suggest that the functioning of the FTs have been rearranged in such a manner that the services of the supporting staff like that of the petitioners will have to be phased out in a time-bound manner. Stop. No such pleadings are available before the court. Stop. Vera. Now, what is the pendency level today? Although the exact figures are not placed before the court. This court is given to understand that substantial number of such references are still pending across the several FTs across the state. Stop. Vera. In Muslim Mandal, in state of Assam versus Muslim Mandal reported in so and so within bracket FB, while deciding the question before the court, a full bench of this court specifically highlighted the speedy dispensation of justice by these foreigners tribunal. Stop. Although the emphasis was on the appointments of judicial or retired judicial officers as presiding officers of various tribunals. The fact remains that in order that these tribunals function effectively and efficiently, mere appointment of judicial officers will not achieve the desired result. Stop. The supporting staff, the tribunal, although not a court, yet has the trappings of a court. And therefore, in order for the tribunal to be functioning efficiently, the services of supporting staff like the LD assistants, bench assistants, typists, stenographers, data entry operators, copyists, office peon, chowkidars, etc., are equally necessary. Stop. As have been discussed above, although for the posts of LD assistant, bench assistant, typists, from a stenographer, grade 2, grade 3, the advertisement issued by the High Court dated 6th of August 2015 reflects a scale of pay for these posts, however, for the data entry operators, copyists, and office peon and chowkidars, no scale of pay is reflected. Stop. These posts were shown to be posts payable on fixed pay system. Stop. While it is true that the petitioners had applied for and had accepted the terms of employment and have been appointed and have continued to render their services, however, the fact remains that their claims for grant of equal pay, or at least consideration of payment of their salaries on scale pay basis rather than on fixed pay, cannot be overlooked, taking into context the various, taking into context the economics as well as the judgments rendered by this court as well as by the apex court time and again. So, in Jagjit Singh reported in so-and-so, the question of parity in pay scale was an issue before the apex court. One of the issues was entitlement of minimum regular pay scale on account of their performing the same duties by the temporary employees. Stop. The apex court, in this authoritative judgment, had elaborately discussed the earlier precedents and have laid down in unequivocal terms that differential treatment meted out to temporary employees on the subject of wages was held to be unsustainable and was set aside. Stop. in respect of the claim of temporary employees, the Apex Court held that there is no room for any doubt that the principle of equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. The principle of these laws, the interpretation of these provisions have been laid down by several judgments which are discussed in the judgment of Jagjit Singh Supla. Stop. These being laws declared by the Apex Court, the same are binding under Article 141 of the Constitution of India. The Apex Court held that for the principle of equal pay for equal work has also been extended to temporary employees within bracket, differently described as work charge, daily wage, casual, ad hoc, contractual, and the like. Apex Court held that it is fallacious to determine artificial parameters to deny the fruits of labor. An employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities, and certainly not in a welfare state. It was held that such an action, besides being demeaning, strikes at the very foundation of human dignity. Anyone who is compelled to work at a lesser wage does not do so voluntarily. He does so to provide food and shelter for his family and at the cost of his self-respect and dignity, at the cost of his self-worth and at the cost of his integrity. For he knows that if he does not accept the lesser wages, his dependents will suffer immensely. It was held that any act of paying less wages as compared to others similarly situate constitutes an act of exploitative enslavement emerging out of a domineering position. Therefore, such actions were considered oppressive, suppressive, and coercive as it compels involuntary subjugation. Stop. Para. Following the judgment of Jagjit Singh, the division bench of this court in an issue where the question was, although primarily of regularization of work charge master role workers, it was held that while the claims of the appellants before the state, claims of the parties before the state for regularization was not maintainable. However, they were entitled to minimum scale of pay and other benefits as entitled. Stop. Reference in this case may be made to the case of what is that division bench judgment? Reported in so and so. Upen Bora, Upen Das, Writ Appeal 54 of so and so, reported in so and so. So, having noticed the law as exfoliated above, the question which falls for consideration of this court is whether the petitioner's claim for pay parity and end obligor, their revision of current remuneration from fixed pay to that of scale pay deserves consideration. Stop. The while the plight of the petitioners have been urged before this court, the petitioners have failed. Petitioners have not referred to any such instances where other similarly situated persons who are employed in the same nature of posts or who are rendering the same or similar nature of work have been granted specific scale of pay while the same has been denied to the petitioners. Stop. While an omnibus submission is made by the petitioners, counsel for the petitioner, that these posts in which the petitioners are presently rendering their services, similar posts are available across various government departments, and the petitioners are entitled to the pay parity with those employees rendering such services in such posts, The question, however, remains is that there was no analogy placed before the court that the nature of work undertaken by the petitioner and those employees rendering services across various departments in the state are one and same, or at least similar nature of work. Stop. Under such circumstances, in the absence of such specific materials placed before the court, the claims of the petitioners that their pay scale, that their pay has to be brought, that they are entitled to pay parity with regard to the scale of pay, which are given to, which are being currently made available to employees across the state who are also rendering such similar who are serving in such similar posts, cannot be entertained in the absence of such specific materials placed before the court. Stop. However, the fact remains that the services rendered by the petitioners are necessary for sustenance and efficiency and functioning of the Foreigners Tribunal, as have been discussed here and above. Stop. There is no material placed that the Foreigners Tribunals are likely to be phased out within a short period of time, or that the services rendered by the petitioners are likely to be phased out or are not required or necessary any longer for the functioning of these Foreigners Tribunal. Stop. It is seen from the proposal forwarded by the state, by the communication dated where is that? Yeah. 201, dated 1st of August 2023, that the state has mooted a proposal for restructure of the remuneration of the supporting working staff engaged in Foreigners Tribunal from fixed pay within courts to scale of pay. Stop. The particulars of the total number of posts available are also mentioned therein. Stop. This proposal, however, stood rejected by the communication dated 28th of August 2023 on the ground that there was an earlier communication of the ministry that the supporting staff are required to be outsourced through contractual basis by the state. However, instead, the state has engaged the supporting staff directly on contract basis through advertisement. And as their services are purely temporary in nature and not governed by rules or regulations applicable to government servants, the proposal mooted by the state is rejected. Para. It appears that the central government is conscious of the judgments rendered by the apex court in the aspect of equality of pay / parity of pay, as have been rendered in Jagjit Singh and other judgments of the apex court. Stop. From the office memorandum dated 4th of September 2019, it appears that the earlier office memorandum stood amended or modified in view of the judgments of the apex court. Stop. Although the specific judgment is not referred to in the OM, it is clear that the central government is conscious of the law laid down by the apex court regarding the grant of minimum wages. Stop. By the said office memorandum dated 4th of September 2019. Although it is issued in the respect of casual workers, it is seen that the government has decided that casual workers be paid 1/30th of the pay of minimum of the relevant pay scale plus dearness allowance for work of 8 hours a day. Stop. This decision stop. As such, the view of the central government in their communication dated 28th of August 2023 that the supporting staff or engaged in the foreigners tribunals being engaged on temporary posts and their services are purely temporary in nature and not governed by the rules and regulations. And as a consequence thereof, the proposal for rearrangement of their remuneration from scale of pay to from fixed pay to scale of pay as proposed by the state government stood rejected, appears to be contrary to the decision of the central government, as is discernible from the office memorandum dated 4th of September 2019. Stop. Where the central government has taken a decision that casual workers are to be paid at the rate of 1/30th of the pay of minimum of the relevant pay scale plus dearness allowance for work of 8 hours, it is unacceptable for the central government to reject the proposal of the state government for restructuring of the pay of the petitioners from fixed pay to scale of pay. Stop. As have been discussed above, the apex court in Jagjit Singh has clearly laid down that the question of parity of pay will also be applicable to all temporary workers, including contractual, ad hoc, etc. Stop. While this court has not rendered a finding that the petitioners are to be granted pay scale equal to any employee engaged under the state government or the central government, the fact remains that in view of the services rendered by the petitioners to the foreigners tribunal, the functioning of which is essential and is necessary for carrying out the mandate of the apex court as well as this court in terms of rendering opinions on the references made by the state agencies regarding the status of nationality of any individual, this court is of the considered view that the cases of the petitioners be reconsidered by the central government, considering the necessity of their services and considering the fact that their services have been renewed from time to time. Stop. The central government will reconsider the proposal forwarded by the state for restructuring the pay from fixed pay to scale of pay, and thereafter pass appropriate orders ensuring that the petitioners are granted a scale of pay instead of a fixed pay as have been granted since their dates of appointment. Stop. This direction is also given by this court in view of the fact that the same advertisement dated 6th of August 2015 reflects that certain posts, namely UDA cum accountant, LD assistant, bench assistant, stenographer grade 2, grade 3, etc., which are also shown to be contractual appointees, their pay structure is shown to be in the pay scale as reflected in these posts. So, where the services of the petitioners are equally indispensable as that of those employees rendering services as UDA, accountant, LDA, bench assistant, stenographers, so and so. There is no justification for the state or the center to continue to give a differential structure of pay to the petitioners on the ground that their supporting staff and their appointments were made on contractual basis. Stop. The respondents will therefore carry out the directions of this court within a period of 90 days. 90 days from the date of receipt of a certified copy of this order, and thereafter pass appropriate orders determining the scale of pay, appropriate scale of pay in which the petitioners can be accommodated and their pay accordingly be continued to be released. Stop. The directions contained in this, given in this judgment, will, however, be prospective in nature. Disposed. MS so-and-so appears for which department? Accountant General. Why is Accountant General required here? Huh? Is Accountant General here? Yes. Why have you made accountant general a party? You are asking for pension also. All right, accountant general. But kiman item asil? 5. Okay. Disposed.
Item number 11.
Mediation? Yes, all right, heard counsel for parties. Mediation. On on 8th of September. 8th of September. Eru format mode mari diba mediation format. Mediation? Yes. No. Why? Oh. If it is not sorted out, it comes back. They are agreeable.
Notice period is required service period is one year also. Less than 1 year, nothing was right.
That was interfered with by a coordinate bench. That clause.
17 November.
That was interfered. Less than 1 year not applicable. That was interfered by a coordinate bench. Whether an appeal has been filed, we don't know. Whatever it may be, you go and find out. Go before mediation. 8th.
Item 14.
Rizik. So what is to be observed?
My lord, I say, my lord, they release the benefit measure. That can be,
Yes.
the officers come and they can.
You mediate before the. If you want, we can do. But it has to be calculated whether you are entitled to the area or not. Your officers will be available when you go for mediation. It will be in your interest only. All right, you want a disposal. All right. Heard counsel for the parties, the petitioners before this court, praying for a direction that the period of suspension of the writ petitioner's late husband is to be regularized, and also to release the arrear family pension, arrears due to the petitioner from the date of retirement to the date of expiry, and pay the family pension and arrear and current GCRG, the petitioner. Stop. Para, it is submitted by the counsel for the petitioner that during the pendency of the writ petition, the pension amount has been released. Pension amount has been released. However, the arrear salary, leave encashment, and GIS amount is left to be released. Stop. The council has prepared a chart which reflects the total amount according to the petitioner. According to the petitioner, is the amount which is payable to the petitioner by the respondent authorities. A total amount of rupees 11 lakhs, not 69, it says 14. I do not know. So where have you added the total? It is 11 lakhs 14,792 area salary. Leave encashment 2,85,000 into 10. According to the petitioner, he is entitled to claim 11 lakhs 14,792 as area salary, 2,85,950 as total leave encashment for 10 months, and rupees 26,108,109 for government employees group insurance scheme. Stop. He submits that the writ petition can be disposed of with a direction to the respondents to release these amounts in a time-bound manner. Mr. A. Choliha, counsel appears for the Finance Department, who submits that these amounts will have to be verified by the department, and thereafter, if found payable, steps will be taken to release the amount. Finance and Health. Accordingly, as agreed to by the counsel for the parties, writ petition stands disposed of with a direction to the respondents number 1 and 3, 1 and 4. To all the respondents to examine the claim of the petitioner in respect of area salary, leave encashment and GIS stated to be payable to the petitioner. And if these amounts as reflected in the chart placed before the court, a copy of which is placed in the case record is found to be payable, the same shall be released expeditiously without further delay within a period of 3 months from the date of receipt of a certified copy of this order. Stop. If there is any variation, if upon verification, if there is any variation in the amounts claimed by the petitioner, then such amounts should also be released without further delay, and upon due notice to the petitioner explaining as to why, as to the calculation arrived at by the department as opposed to the claims made by the petitioner. Disposed. No order is to cost.
15.
None appears for the petitioner and called. None had appeared for the petitioner when the matter was listed earlier. Mr. J.K. Goswami appears for the state government. It appears that the petitioner is not inclined to pursue the matter. Dismissed for non-prosecution. Interim orders, if any, stand vacated.
16.
Mediation, all right. Send for mediation on 9th of September. Give your particulars to the court master.
17.
No, last order is for referring it to mediation. 5-8, then? You go before mediation. The matter has already been referred to mediation by order dated 5-8-2025. However, no specific date has been fixed. Accordingly, let this matter be referred to mediation on 9th of September. The J.K. Goswami appears for the respondent.
18.
Hearing. It is for mediation. Go and try in the mediation if it works. Yes. Heard counsel for parties has agreed to this for mediation. On 9th of September? Yes. None appears. None appears for the petitioner on call. Mr. M.H. Loskor appears for respondent 7. Matter stands passed over to be listed next week. Who's for the respondent here? Where is PWD? An accountant general also. Yes. PWD. PWD. You wait for some time, let us see.
Supplementary list for admission item 106.
Yes. You are the second wife. Then you are the third wife. No other wives. First wife died. No, after third, no. He died. Okay. He has two. Anyways, so now you are claiming the benefit for your children. Yes. CGC. Hmm. Hmm. CCS pension. Oh. Hmm. You're referring to Rule 50? Hmm. 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 Now, who is included in the family? Where is it, that definition? Hmm. Is the CCS rules dealt there in the judgment? No. Then? All right. We'll fix it for hearing then. Matter be listed for hearing. That means what? Pleadings are complete. Right. Issue rule, matter be listed for hearing. In the month of September on a date to be fixed by the registry. 18th of September. All right, 18th of September.
For hearing, I think 24 to 31. 31.
Yes. Hmm? Hmm? What is your claim? Wrongly removed. You are not selected. Did you get to appear? You were not called. Ah. All right. Then what happened? He is also removed. Why? Why?
After complaints. And these complaints were examined. In the course of this journal, investigative, we found that out of these 44, there were anomalies in respect of 7 candidates. Some were wrongly not called for the next round. And that's how the people who were working on probation were wrongly appointed. They have been terminated. So there are two sets of victims. First set, the Papwani and the RM Dekar client. They are the complainant, based on which this investigation, they have filed victim. And then there is a second batch of investigations by Mr. Dekar client. They are the ones who have been terminated, who are serving on probation. And those terminations are available.
Now, what is the stand of the department? You have found out that there were some anomalies, so you removed them.
Orders of termination.
And so far as the writ petition, clients of Mr. Patwari and Dekar, they
would now have to be, we are left with two choices. Either we proceed with that selection process itself, call them, and if anyone else was wrongly left. Or else we re-advertise.
So what have you decided?
We are awaiting matters are pending. We haven't taken them.
You take a call and apprise the court what you want to do, we'll decide. If you want to proceed with this election, what is the point of hearing it now? You call them.
Because both sets are before the law.
And what is your ground for challenge?
Complaint initially was with regard to item number 24, the petitioner. They said that that petitioner was in the OBC category. They say an age relaxation was not accorded, therefore they moved out of the freedom. That is how I stepped in. Now, during the petition filed by Patwari's time, initially the stand of the IOC was that they are not entitled to the age relaxation that they are saying. Subsequently, while the petition was pending, they carried out the scheme of termination where they said that there was anomaly in the recruitment process and therefore we are terminating not just the petitioner in item number 24, but 5 others. Now, these petitioners are challenging on the ground that firstly, the period of probation was already over by then. And secondly, we were not even afforded an opportunity to respond, not even a show cause. And these terminations are, though they are said to be simpliciter, termination simpliciter, actually in our contention it is punitive in it. Because there were allegations that there has been manipulation in mark. There was also an allegation that experience certificates were not properly filed. So that is how the item number 24, 27, 31 are.
Right. Will you complete within 15 minutes? Are you sure? It appears to be over within 10 minutes or so. No.
Both in my favor, be over it.
All right. Counsel for the parties have been heard. Due to paucity of time, matters stand deferred to be listed again. There'll be a court.
Can it be on 16th of September? Getting the.
16th? All right. List on 16th as agreed to by the counsel for the parties. Interim orders wherever passed will continue till the next date of listing. Yes, Mr. J. Patwari and Deka and Mr. Deka appears for, you give your particulars, Mr. Rai Chaudhary assisted by MS appears for IUC. Health urgency. Okay. Yes. List again after a week. 1 week. It's difficult to give you a fixed date every day. Fourth September. On the request made by the counsel for respondent. Counsel for the petitioner, for the parties, submit that the matter be listed on a fixed date, on some other date. When? November? This month? This month, 28? 2nd? 2nd September only. Fourth. List on 4th. The request made by the counsel for petitioner.
Items 35 to 60.
This has to be on some other day. Who's representing the respondents? First, you have to tell us under what provision you have the authority to go for a re-evaluation. When do you want to file the affidavit? You're filing it today. The affidavit be filed. Affidavit is sought to be filed by the respondent authority. Health department, health, bringing certain additional particulars. He prays for 2 weeks' time. Counsel appearing for the petitioners. Any objection? List again after 2 weeks. It will be in October only. 16th October. Will it be ready by 16th of September? All right, 16th September.
Item 61 to 85.
Yes, sorry.
And we know where we stand as far as the time is concerned. I had a request. Of course, we are supplying the state. And therefore, also, in the file in January, no stay application.
No. First tell us what are these matters.
1 to 85. The first trend minus and 86 to 1 to. The gain of the rate. These are matters. Excelling minutes the open department and matters the suspension order. Which are premise matter. Now, okay, it is premise on a 120 report. We have challenged the validity of the report. The ground that the commission matters flouted 8B and 8C of the commission's required guide. Mainly matter, we inquired into the conduct of the petition without giving a notice on the 8B to appear before the. The lordship knows that law otherwise is well settled. If you flout 8B matter, then the entire proceeding for the commission goes. The report is not binding and void. So on that ground matter, my petitions were Dismissed matter 6 December 2020, something of concern matter, I didn't want to bother you about it. 6 December 2024 matter, the order is stayed by 10th January 2025 matter. Suspension order is stayed, the so-called notice is stayed after getting the matter on the ground of the HBL 18 on top. 10th January 2025 matter. Since there was non-compliance of the order, you can direct it, reinstatement of all the right. Despite that order, both the orders were put up to challenge for the people. Division bench on 19th December 2025 of that, 19th February 2025, and headed by Justice Surana, dismissed the writ. First holding that the state has not filed their stay before the single death. Straight away they have come before the division bench. The matter is wide open before the division bench also arrived at a finding that these orders of 6 December 2024 and 10 January 2025 does not suffer from any illegality or anomaly requiring interference by people. Those orders have been retained. Till date, my friends, client, but state surprise has not increased. So
You have not filed any contempt so far. Okay.
Now, what has happened is this. Not only are they not compliant, statements are made all across that they are not compliant with the order. So the statement made in that. I have filed an application to your order. That matter came up before Justice Tribunal. Justice Tribunal by a detailed order, issued notice, and that application when it brought take up the matter. Brought to take up that application because my contention is unless they purge themselves of the contempt, they cannot be. So these proceedings which have to be heard. So far as I can stick to 1 and 85. 86-103 minutes are issues I friend Patwari and all the peers. That's on the point, that simultaneous departmental proceedings and criminal proceedings, the same set of facts, what is stated. That's another set.
Lordship offer what is the state's perspective. The Lordship, there are two batches in the APSC cash for jobs.
There is no cash for jobs here.
There's the code. I didn't enter. No, the Lordship, that is my case.
Very trying to respect.
I have the Lordship.
There is no cash for jobs.
I am just simply stating
Even
what is the
this
charge.
believe the state stand.
I'm sorry.
Very
No,
hard.
I'm sorry. No, I'm sorry. I will not take a certificate of fairness or unfairness from the
All right, you will permit you to use the word scam.
Lordship. I will come to that. I'm grateful for that. The APSC Lordship scam pertains to the allegation of people who made it into service by paying.
Alleged scam.
Yes.
All right.
Alleged. The APSC alleged scam on which Lordship, irrespective of the proceedings, there are charge sheets filed and there are criminal cases. There are two batches. They all relate to the 13-14. In the first batch, Lordship, the learned single judge, this court is in our favor, upholding the discharge. I must give this because these are get intermixed. Upholding the discharge of the state because all of the petitioners who were discharged had not completed the maximum period of 4 years under which they can be probation. So therefore, the argument was that 309 article does not. Because under the rules, you have a 2-year probation extendable by another 2 years, except the APSC police, where no upper limit is defined. Now that's a separate. That was a assailed Lordship. It came up before the division bench. During that proceedings, in one particular petition, writ petition 75, an argument was professed that there has been unequal treatment by the states, and there was a 9-page tabulation on which action should happen. In the meantime, a commission of inquiry had been appointed under Justice Sharma way back in 19. Now the second batch emanates from that, which is the cases before Lordship. The first batch Lordship has gone, Justice Surana has passed that order. I told my learned friends were here yesterday, and I think notice has been issued. Next date is probably 4th. We have waited 4 times 4, but I stand corrected. The order is not out. Dates. Whenever it is. Yeah, I'm told it will be till the next week. In any case, Lordship, there also will satisfy Lordship on the act of the state. But now coming to the current batch is the second batch. These are all persons, Lordship, who have been named in the Commission of Inquiry Act, and then they have been named in Charge Sheet 14, 12 to 14, which has come out because of writ petition 75. And they are basically the allegation is after forensic audit, etc., forensic investigation, there is an enhancement of marks. Now, in this particular batch, Lordship, PP, a show cause notice was issued, suspension order was issued, and the departmental proceedings were to start. My learned friends filed petitions on two grounds, as Mr. Tovey has pointed out. One is assailing it on section 8B and C, and the second ground being that parallel proceedings between criminal and the DP should be stayed. That's the two grounds. In this lordship, the state, respectfully I would say, and it's the factual position, did not file the affidavits on time. Eventually, 6th of December, there was an order of stay. Reinstatement ordered in January. It is at that point that the state, well, let's say lordship filed it, decided to get into its entire proceedings, and two things happened. Vacation of stay applications were filed in all of them, and we preferred an appeal for Justice Surana, in which my learned friends' reading of that judgment is that they are findings against us. Our reading is that the merits were not met because there's a specific sentence, and that liberty was given. Come back to the signature. Anyway, that is what lordship will adjudicate. Now, vacation of stay applications are pending since February, in which the law is also settled. We will satisfy that purging of contempt will only
It
arise.
was an ex parte order.
Yes, lordship, no, state was there.
After hearing
Oh, then
So lordship replies were not filed.
after hearing my friend was not there.
where's the question of vacation now? Modification, you are seeking modification.
I learned it. Allow me to finish. I can out-shout him, but I don't wish. But lordship, now we filed vacation of stay applications in all matters in February. There is a detailed order of 7th of April. Lordship may open that. Our ground is lordship, indication that the final, at the interim state, the final relief has been granted. And because in a show cause notice, no.
Then you went in appeal B against that. Huh.
And the vacation application was considered by the 7th of April. Lordship, it comes to 7th of April. That is the order which you sent the note.
Hmm.
Yeah, you read it all?
Yes.
My learned friend, Mr. Chaudhary, assisted by Ms. Chaudhary, so and so on, in this matter of petitions, show cause notice dated 30/11/23 as well as order of suspension, also dated 30/11/23, issued to individual writ petitioners placing them under suspension, have been assailed inter alia on the ground that the one-man commission report was flawed. One, due to violation of various statutory provisions and therefore reliance on the one-man commission's report while issuing the impugned show cause notice suspension order has a vitiating effect on the said orders. Mr. Chaudhary, for the writ petitioner, further submits that since the petitioners have already suffered prolonged suspension, hence this is a fit case where the impugned orders of suspension deserve to be interdicted by this court. Per contra, lordship, I have argued that appearing for the respondents on the other hand, submits that this is a batch of writ petitions pending before this court on the same issue and the state government has already filed IAs, so and so, praying for vacating the interim orders earlier passed by this court, suspending the departmental proceedings as well as the suspension order, which is in the nature of granting final relief to the writ petitioners. Under these circumstances, either the IAs be taken up first or the writ petitions be heard and decided on merit at an early date. Learned counsels have both agreed to an early hearing and final disposal of the writ petitions by submitting that the subject to a definite schedule of exchange of meetings and hearing claimed by the court for final hearing of all writ petitions, they are agreeable to such an order. The lordship may come to the end. I raised the question of the content, which is what the court holds in the last para. However, taking note of the submission of Mr. Kohli that contempt petitions are pending against the officials, he is given liberty to suitably mention the matters as and when the contempt cases are listed before the court. So this court lordship felt in its wisdom that let's hear it finally rather than hearing the IAs for vacation separately, because the commonality of arguments are enormous. The IA has an additional ground that final relief has been given at the interim state. It was fixed for 29th and 30th of May, and then Lordship Suman Sham was transferred to Bombay High Court. Then it came up on another day, it couldn't be heard, and now we are before Lordship. So where we stand, Lordship, our case is for the state that since there is an order of state, DPs are not proceedings. Either the matter has to be heard finally on a fixed date, or lordships be required to argue on the vacation of the stay. We are in your hands, therefore lordship file.
But just to complete the narration matter, will lordship also have 6 December 2024?
6th December.
Notice was issued matter in November.
In which matter is it?
First matter, I get
5862. What is this? 5860. Item 62. What is item 62? 5862. Yeah. Sorry?
just at 6/12/2024. For that matter, the order of 13 November 2024, the first order.
Yes.
After the detailed order records my contention on account of certain irrigation better to look at that. So 1 million inquiry commission was constituted precisely for the entire content commission totally of document detected certain anomalies for which purpose the house to be involved certain. So given a notice, including the written on 13,000. Same was responded to the written submitting a district. While the matter listed at that respondent not were taken service. Much later point of time, 30th November, suspended the written but also issued that local notice. Learned senior counsel submits that the very initiation of the inquiry against the petitioner is void in law on account of gross violation of the inquiry. Therefore, the proceedings initiated against the petitioner should be set. He further submits the pending disposal to petitioner be given protection by this court as the petitioner is undergoing immense pressure and inconvenience to inquiry inquiry. Having regard to the above predictions, the matter needs to be examined by the court, for which letter notice is to be brought. 6 minutes also issued notice of the interim taking it without. Matter is fixed matter for 6 December. In the meanwhile, 25th November, you know, in order of justice higher. Notice is issued by the departmental proceedings officers who appear before the department. Court state that notice. If the notice says that, now, madam, on 6 December 2024, that's a court.
Yes.
We are 8 months down that order, the order is yet not complied with. What should have the 6 December, madam? Just have the last, having regard to the protection, having regard to the protection, this court is inclined to say the notice dated 30th November 2023 necessary. And the so-called notice dated 30th November 2023 till the next returnable date. Are appearing for the home and shall produce the relevant records, including the one-man inquiry commission report before the next day. Right, my lord? Then have the 10th January order.
Yes. Yes.
Justice UK Diana Gilman. Mr. Chaudhary, learned senior counsel assisted by so-and-so, submits that in spite of the fact that the orders impugns, including the order of suspension, having been stayed by this court by the order dated 6/12, and the same having been apprised to the respondent authorities, petitioner is not allowed to resume their services. Para 3, Mr. Chaudhary, learned sending counsel opinion, submits that in view of the fact that by the order dated 6/12, this court, while staying the operation of the order of suspension as well as show cause notice, had not passed any orders towards directing the respondent authorities to permit the petitioner to resume his services. The respondent authorities were not in a position to permit the petitioner to resume. The above submission of Mr. Chaudhary is clearly not acceptable, inasmuch as the order of suspension having been stayed by this court, the natural corollary would be that the petitioner continues to remain in service. Accordingly, are directed to take steps for consequential orders. And para 8, consequential order is now be called for in pursuance to the license passed by this court, either by order dated 6/12 shall be issued by the respondent within a period of 1 week from today. 1 week expired on 17th January 2025. Now, please have the division bench judgment, my friend has handed over.
Yes.
Of 19th December.
Let's show that
19th
para
February.
33.
No, we have to rise now because
I understand.
there's a meeting.
Very well.
We have to.
Lordship,
Yes,
fix the
tell
date,
us.
my lord.
So Lordship, I am just praying that if Lordship and the understanding on the last date was equally as this, that we will be going for a final hearing, but Lordship, if time is an issue, we are pressing for the vacation of stay because we are suffering it. So now Lordship may either choose to hear the vacation of stay or Lordship may use the final matter, whichever, on a day that Lordship chooses, as soon as possible, Lordship.
As soon as possible.
I was just saying, Lordship, I don't know, subject to Lordship's convenience.
Yeah.
Fourth is already one matter that's kept. I don't know if Lordship third or fifth would be possible.
Fourth.
Fourth, there, because Lordship, we may keep the batches separate, it'll lead to a lot of.
Use batches, man. Take
Yes.
some time.
So Lordship, if it can be kept on fifth, the next date, so we can then Lordship easily be here and one day one batch, one day another batch. I'm just requesting subject to Lordship's convenience.
We can have it on second or if you want.
Second,
No,
Lordship, third, or if third is possible, Lordship.
third,
Third, Lordship.
third,
I have
fourth,
a
fifth.
Personal difficulty.
Okay, no problem.
Personal
Fifth,
difficulties.
yes, fifth, Lordship, the next day.
Can we have it, my lord, subject to my friend's convenience, 17th or 24th, any?
Lordship, I am praying for vacation of stay. So my vacation applications can be
24th
kept.
Would be 2 days before the long.
Yes,
weekend.
Lordship. And that's why, Lordship, I'm praying my vacation of stay can be kept separate, Lordship. Lordship, I'm praying for the first week, Lordship. For vacation, at least. The final matter can be kept anytime, Lordship. September, October. Yes, Lordship. One minute. No, no, Lordship.
No, no, whatever.
Whatever.
Please have the
No,
division
Lordship.
bench order, but I've stopped at that. Just have the division bench order.
Lordship,
Just
on
one
the
paragraph.
division bench also, I can show something.
One paragraph.
We will look into it, whether it is the vacation or the entire matter, but some date you'll have to agree.
Lordship, can I request for fifth? Because fourth, in any case, is there, Lordship, and I'm just requesting for fifth, Lordship. Third, fifth, whatever suits other
Yes,
families.
Mr. Chaudhary,
Third or fifth, whatever works for
Mondays and Fridays, I understand, miscellaneous
That's
days.
the problem.
them. Friday,
All right, Tuesday, Wednesday,
Fifth is
Thursday.
off. Fifth, release off.
Release off.
Oh, इसलिए तो बोल रहा हूँ. Fifth, release off. No?
We'll post it on third.
Fourth, third, I have a.
Fourth will be two batches, Lordship, and your whole day will go in both the batches. I must warn Lordship. Then Lordship would like to fix a time.
What else do you want us to do for the whole day? That's what we do.
Lordship, it's a fair comment, but I think between the first and the second, the issues are very different. But I'm okay. Lordship would like to fix this at 2 p.m. then, Lordship?
We don't know. I mean, it'll be listed. You, as per your convenience, you make a mention and get it done.
In the morning?
Yeah.
Third, fifth is not working, yeah.
As agreed to by council for parties, all these matter, this series of matters be listed on 4th.
Yeah, fourth.
4th of September. Correct. An attempt would be made to proceed with the hearing of the matters.
Lordship may just record my one, Lordship, I have just request. My one submission is that I'm pressing for I have pressed for an early.
The respondents are permitted to renew their prayer for
Vacation of.
pressing their IS.
Including my IA, 1564. There's an IA I have filed. with.
All right, the council are permitted to renew their prayer for pressing the IS.
Grateful. The interim orders to continue.
Interim orders will continue till the next day.
Till the next day. I'm
Grateful.
so grateful, Lord.
Huh? Pass over.